those are all pluses. Ms. Vasquez. I don't think you owe me any money. Now, the problem here is the no contact provision is still in effect. And the prosecutor is unwilling to make any sort of plea offer. Mr. Kuhn has a view of this, and I think he wishes the whole thing would go away. But it's up to the county prosecutor. So I'm more comfortable now having let you out of custody. But you guys need to stay away from each other until this matter is resolved. And I don't want you both freezing to death in the back of a Yukon someplace or Suburban. So you stay in contact with your lawyer. We'll set a pretrial on a Thursday afternoon on a date that works for your attorney. All right, thank you.
Thank you, Your Honor.
All right, now we're gonna do the Casey Strong matters. Let's talk to Mitchell Salmon. Good morning, sir. Are you Mitchell Salmon?
Yes, sir.
And we've met. I just needed to identify you for the record. You got charged with assault and battery. That's alleged that you punched Brody Jack Johnson. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Prosecutors agreed to dismiss that charge for a plea to disturbing the peace. Disturbing the peace is a misdemeanor. It's an old-fashioned general one, 90 days and or $100. I guess that's it. It doesn't carry a firearm restriction. Disturbing the peace doesn't matter who was right or wrong or who started it. Was there a quarrel, argument, or disturbance in a public place? Mr. Salmon, are you going to plead to that charge?
No, Your Honor, he's not.
Oh, he's
We're
not.
asking for
I
last
misunderstood
pretrial.
this also. Oh, I'm disappointed. Frankly, I was surprised they made an offer to disturbing the peace. Okay, we'll settle last pretrial. I misunderstood, Mr. Salmon. I thought you were going to get this matter over with. Yeah, $200 fine and time served, but you do have a right to have a trial on this if you wish. You already owe me money on the earlier assault and battery of $300 by December 1st.
I'm gonna make a payment today, Your Honor.
All right. I can just put you in jail for 5 days and wipe out the $300.
I'll pay it.
All right, please do. You rejected the plea offer, which is your right. You don't need 2 assault batteries on your record. I want you to go out there and make a payment on that other case. It was actually supposed to be paid a few days ago. Even if you don't pay the whole thing, I want you to pay something on it.
Yes, sir.
And we'll set this for a final pretrial on a Thursday or other day that works for your lawyer. It might not be until January. Are you still at the West Street address?
Yes, sir.
All right. The reason I want to talk to everybody, even the ones that we don't resolve, is to talk about whether they're still at the same address, whether they're violating any of the bond conditions, and whether they owe me money. And a lot of people owe me money, but I thought I had this matter resolved, and I guess I didn't. All right, Mr. Salmon, you're good to go.
You're all set?
let's see if I better look more carefully.
The only plea is Corey Miller. The other two, Eberly and Conanen, are.
All right, let's talk to Sean Conlon.
Sure.
I didn't figure this one was gonna be resolved, but I was hopeful. This is People versus Sean Lee Conanen. You're charged with Three Rivers ordinance violation of disorderly person. There was a video. I think people were gonna take a look at that. You pled that not guilty and were quite adamant in your position. You wish to continue that plea of not guilty? You have to speak your answer. All right. Disturbing the peace under Three Rivers ordinance is a misdemeanor. It's punishable by up to 90 days in jail. This is called disorderly person. I think under ordinance, it's 93 days in jail and a fine of up to $500. All right, maybe we'll have a bunch of trials for disturbing the peace, but I don't think the city was willing to budge, and neither were you. Just as a point of information, the normal fine and cost for this is $100 plus costs. It does carry a potential jail sentence, but that doesn't have very much. Are you still at the Patterson Road address in Constantine? All right, you're free to go. Same thing, we'll set a free trial on a date that works for your lawyer, which hopefully will be a Thursday. Brooke Eberly. Good morning.
Good morning.
This is file number 242235 ST. And 251420 ST. You got two charges of disorder or driving suspended. Driving suspended is a very common, maybe most common offense. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driver's license and requires that your license be suspended. You got two of these. You got one in December of 2024. Then you missed several dates and they finally caught back up with you. And then you got another one in July of 2025. You have $1,129 of unpaid fines and costs. One of them is a previous driving suspended that was reduced to allowing another to violate the motor vehicle code. And then you've got several other plate and insurance cases that looks like they got defaulted. So $1,129. The plea offer sheet from the prosecutor, I think these are both under state statute, says the offer was to plead one and dismiss one. At this point, she's not willing to do that.
Your Honor, the offer was a plea to allowing another to violate the motor vehicle code. If she had had her license reinstated, she's working on getting her license reinstated. We're asking that this get set for last pretrial to allow her time to do that. If at the time of last pretrial.
One thing she could also do is pay her last fine for when she got a break like this. They reduced, allowing another to violate the motor vehicle code carries no points, and it doesn't get abstract to your driver's license. So it will allow you to try to get your license. So you haven't paid the fine from the last one, plus the insurance and registration stuff has to do with not having any money. So you get a driving suspended, then you don't show up for court, then you get another driving suspended, and you don't pay the fines. That's not a very good posture to be in when you come in for sentencing. Are you still at the Ash Road address?
Correct.
How'd you get here today?
My mom.
All right, don't drive anymore to
No.
make it worse
No,
between
no.
now and then. All right, we'll have a bunch of final three trials on a Thursday. You're good to go. Well, just before you do go, what are you actually doing to try to get your license back?
I had to request an administrative review of my driver's license to figure out why they even got suspended in the first place. So, and then I have to go to where the root cause of it is. And from my understanding, it's because of a automatic renewal for a registration that I didn't have any for a car that I didn't have no more. So I had to
Let's
request.
take a look. In the old days, they used to suspend you for unpaid tickets, like these no proof of insurance and no registration. They would suspend that for what's called FCJ, failing to comply with
Yeah.
judgment. They don't do that like they used to, although frankly, I agree with it. If you get a ticket and you don't pay it, I don't mind the fact that you get suspended. But you were already suspended before that started.
Yeah, it was in 2020. It was, I was set up for an automatic payment plan for my registration. And COVID hit, they repossessed my car, so I no longer had the car. And in October, when they tried to push that payment through, there was no money in the account and it came back.
Well,
as a balance
you're
check.
on what I call the driving suspended merry-go-round, and it's very hard to get off of it. And this isn't in my queue, Matt. Luke. See what I can tell you. So have they scheduled it? Is this imminent or is this something they're going to do in July?
No, she told me they would get back with me within 7 to 14 days after they reviewed everything.
All right, when was that?
That was it was Tuesday when I talked to them.
All right. Well, this will probably not be until after the first of the year. Boy, there's a lot of stuff on here. 3-5. Let's see if I can give you any insight. Shows that you are suspended. You have these 2 unpaid no insurance tickets, one from March of 23 and one from July of 23. You have a driving without a license. According to this, you bounced a check.
That was the auto renewal online,
Okay.
correct? Yep. That's what
Actually,
started the sole suspension.
there's not that much baggage on here.
Right.
Just these. Now they aren't going to say, okay, great, we're going to give you your license back. And you've got all these unpaid tickets. So some of this involves money.
Okay.
You've got a number of unpaid tickets. They don't no longer suspend you for it,
Mhm.
but they won't give it back either. So plus you've got the one that's the misdemeanor, which you could go to jail for. I'm going to give you something that shows all the tickets that you have.
Okay.
Now, some of these, I think you got a ticket and then just didn't answer it. So those just get defaulted on a civil infraction. You didn't have a trial, you didn't get found guilty, you just didn't show up. And so that happened twice in the year of 23. So if you get another driving suspended, it's going to undo your ability to get your license for a while. But you really don't have that much bad stuff on here,
Okay.
just some unpaid tickets and some other old stuff. All right, there's what your tickets are.
Thank you very much.
And district court clerk is right at the end of that.
Okay.
It will be in touch. Well, I appreciate it. Thank you.
All right, we've yet to do a plea today. One day earlier this fall, we did 28 pleas. I'm not even sure how we did it, but we'll probably have maybe 8. This is Corey David Miller. Good morning, Mr. Miller. Good morning, sir. All right, this is People versus Corey Miller, and again, we've met. Mr. Miller is charged with assault and battery and disorderly person. So let me pull this up.
And this is going to be a no contest. I do have the bond information report if the court needs it.
All right, well, let's find out. Mr. Miller lives up closer to Detroit.
Yes, sir.
He's been here for every hearing. Good morning. Let me find it.
Yes.
Okay, I know that Pruden is ready, but I don't have a court officer there yet.
Okay.
Pruden. This is a 2018 charge. May 15, 2018, he was at Holiday Market and he allegedly stole, and he's being charged with a misdemeanor, 1 year retail fraud, second. He's never appeared. It looks like he has some housing instability, so we'll have to address that. I don't have an address for him.
Okay.
So that one's ready. And which one is that again? Okay, Pruden. So as soon as we have the court officer, and then I have a swear to, but that won't be you. And that's it for right now. So just hang tight, or you want us to call you when we're ready?
I'll just be in the background if you don't mind.
Madam Clerk, when do you think we'll have a court officer over there?
I can go over there right now.
Right now?
Do you have the price?
I have the file. There's only one ready, right?
Yes.
Okay. All right. Everyone else, I'll check you in. I'll be right back. I have to get my docket. I forgot to bring it with me when I came out. 1 second. Fall, Dearborn Heights address, and I do not have a phone number. So if you could verify the contact information, the court would
Okay.
appreciate it. Okay, Mr. Merritt, can you please join room 1 with Attorney Cole? She's going to assist you today with the arraignment. Okay.
Okay.
Thank you, sir. Okay, Beth Adams, are you my informal? Okay, do I have Tome Perez on the phone? Tome Perez.
I'm sorry.
Yeah.
Sorry, Your Honor. How
Okay,
do I-
1 second. I want you to go to 1 second. Mr. Mayor.
I don't do that. I'm sorry.
Did you get an invite now?
Yeah.
Okay, join. Thanks. Okay, good morning, Officer. Let's see, Adams. Okay, is there someone on here named Tome Perez?
Yes, present.
Okay, do you need an interpreter to assist you?
No, I don't.
Okay. Okay, and who is on the phone, on the Zoom, sorry, with the phone number 248392? Could you identify yourself, the person on the phone?
Yeah, this is Maria Manuel. I am Jesus's wife. I was the driver of the car.
Oh, you're here for, okay, so.
But yeah, same case of. I
Okay,
think you
one
call him
second,
Tepe.
1 second, please. So do you go by the last name Perez or is it Tome Perez?
My last name is Manuel. M-A-N.
Oh, Manuel. Okay.
Yes.
Manual?
Yes, correct.
Okay, thank you, ma'am. All right, I'm
you.
gonna call that case now. Calling the case of CH 000041. This is the City of Royal Oak versus Jesus Marie Tome Perez. Your appearances, please. That means tell me your name. That will start with the trooper, and then we'll have the defendant driver and the wife identify their legal names, please.
My name's Elizabeth Adams.
Okay, good morning, ma'am. Thank you for
Good
appearing
morning.
today. It's today 5. Okay, and the driver, Mr. Tome Perez, please tell me your name.
Jesus Tome. I was not the driver. I owned the car, but the
Okay.
driver was
And
my
the driver,
wife.
okay, and the wife, Miss Manuel, will you state your legal name on the record?
Yes, my name is Maria Manuel.
Okay, good morning. My name is Jill Banky. I'm the magistrate assigned to hear your informal hearing today. You have a parking ticket at the hospital. And do you want to admit responsibility with explanation or deny responsibility and have an informal hearing?
No, I mean, I just didn't understand. That's why I wrote the letter.
Was there a letter here? 1 second.
Yeah, I wrote a letter.
Okay, 1 second. Let me review the letter.
Okay. Okay.
Okay, she did write a letter where she admitted responsibility with explanation. Do you have any position, Officer Adams?
I didn't know there was a letter.
I didn't either. I
received
just
the
saw it
notice.
in the. Okay, so
Here.
what is your position? She admits responsibility. What is your position on this ticket, please?
I don't know. I was just told to write the ticket from dispatch. So I don't mind if it's dismissed. Just as long as they know that they can't park in valet without paying. That was just the thing.
Oh, okay, so this was a valet section. Okay, ma'am, do you understand? I don't know if you're going to have to go to the hospital for other appointments or treatments, but do you understand that where you parked is valet and that you have to pay to park there?
Yeah, I didn't know that.
Okay, but if you go there again, will you recognize the lot?
Yeah.
And will you know next
Oh,
time?
yeah. Yeah, for sure. I had to go back. So yeah, for sure. Now, knowing it's valet area, I will not park for sure.
Okay, well, the court, because you admitted responsibility, the court finds you responsible, but I'm waiving all the fines and costs. So there's no money due, okay?
Okay, thank you.
You understand? Okay, so I don't know what's going on with you, but I wish you well and good luck with your treatments, okay? I hope you feel
Thank you so
better.
much.
Okay, I wish
Thank
you
you.
well.
Thank you so much.
All right, take care. Thank you.
Bye-bye.
Ms.
Bye-bye.
Adams, was that your only ticket this morning?
That was my only ticket.
Okay, thank you. You may leave the Zoom.
Thank you. Bye-bye.
Okay, thanks. Mr. Lately, the attorney is talking to someone else in a breakout room. When we're done with that case, I'll put you in a breakout room with her to discuss your case.
Okay,
Thank you. Just give me a second, but we have you checked in, okay?
okay.
Good morning, jail. How are you?
Here.
Mr. Angot, ROPD jail, do you have Mr. Pruden with you?
Yes.
Okay, so Mr. Angot, written in the file is an address on Martin Luther King in Pontiac. So if you could confirm that address, I would appreciate that.
Sure will.
I don't have any kind of phone number for this gentleman.
Okay,
Okay, thank you.
thank you, Judge.
Will the jail kindly and Mr. Angot kindly go to room 2?
Got it.
Thank you. Mr. Gothard is here. Detective, are you available for the swear to?
Morning, Your Honor.
Good morning. How are you?
Good, how are you?
Good. Did you have a nice holiday, sir?
Yeah, it was nice.
Yeah, I feel like I haven't been here forever. I have 1 week off. It's like, I feel like like I'm my first day on the job. Okay, calling case number 2501985. This is the state of Michigan versus Grace Marie Quarker. Is it Quaker or Quarker?
I think it's Quarker.
Okay, this is the date and time set for the swear to. The court has before it a complaint / general information wherein it is alleged that on or about July 8th, 2025 in the city of Berkeley, that the defendant Quaker did contrary to law, utter and published an instrument at Credit Union 1. The proposed complaint contains the signature of the assistant prosecuting attorney and that of the complaining witness. Will you raise your right hand, sir? Do you swear or affirm that the testimony you're about to give in support of the felony complaint is true?
I do, Your Honor.
Is that your signature on the document?
It is.
Okay, the court will take your testimony, please.
Detective Brian Gothard, Berkeley Department of Public Safety, referencing our case number 25-10088. On July 8th, 2025 at 11:07 hours, Grace Marie Quarker, born March 11th, 2004, is seen depositing a $1,650 check at the Credit Union 1 drive-through ATM from the passenger seat of a silver Dodge Durango with Michigan plate Edward Victor Tom 8529. After making this deposit, Quarker then enters the Berkeley branch and deposits endorsed check number 6754 drawn from the U.S. bank account of acclaimed visiting nurses paid to the order of Grace Quarker in the amount of $1,736.16. Quarker received $1,636 from the deposit, exits the branch, and is seen leaving in the silver Durango she arrived in. On July 10th, 2025, check number 6754 was returned to Credit Union 1 by U.S. Bank as they were unable to locate the account. Quarker was identified with her Michigan ops she provided to the teller to complete the transaction. The endorsement signature on the back of check 6754 closely resembles that of Quarker's Miters SOS return, and the suspect on video matches that of Quarker's ops. A search warrant for the T-Mobile phone records of Quarker showed her in the immediate area of Credit Union 1 branch located at 28845 Woodward Avenue on July 8th, 2025 at the time of the fraudulent transaction.
Okay, the court has heard the testimony of the complaining witness. The court finds that probable cause has been established for the issuance of the complaint and warrant, and the charges are not frivolous and or capricious. As such, the complaint and warrant will be signed. Is there anything further requested or required of the court at this time, Detective?
No, Your Honor, I'm all set.
Okay, thank you. Take care. Be well.
Yep, have a good day.
You too. What should I order for lunch?
the warrant stayed open. They checked it a couple of times. We sent him a notice to show cause. The Google search said he still lived at the same address, so he responded. We recalled the warrant and set the matter for pretrial today. So the prosecutor has reviewed it, and apparently prosecution and or the complainant wish to maintain that charge of assault and battery. Assault and battery, as I indicated, is punishable by up to 93 days in jail and a fine of up to $500. Prosecutor has offered that if defendant pleads to assault and battery by no contest, they will dismiss the charge of disturbing the peace, disorderly person. They're recommending time served, fine and cost, no probation, and no additional jail. Ms. Strong, is that your understanding?
That's my understanding. And my understanding is it's a sentencing agreement.
Okay, so if I don't follow the agreement, he would have a right to withdraw his plea.
Yes, Your Honor.
And I don't have an objection to that. I didn't discuss it with him, but this case is several years old. As I said, I had reviewed it several times over the years and renewed the warrant. This is a road rage situation. All right, Mr. Miller, do you understand that if you do plead to this charge, you'll be giving up all the rights that are on your advice of rights? And you sign that here. So yes, all right. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you allow or accept that a conviction would enter. Do you understand?
Yes, sir.
Anybody threaten you to get you to do this?
No.
I promise you anything. All right, by pleading no contest, I'm going to get the factual basis from the bond information report, which your attorney referred to. We're going to dismiss the disturbing the peace or disorderly. True, the officers arrived at Balk Road and Sherman Mills Road for report of a male subject, Corey David Miller, who was walking in the roadway yelling at cars. We were en route and advised the male subject had stopped a car in the roadway and reached inside the car and assaulted the driver. I made contact with Mason Booth, who stated he had passed Mr. Miller on the way to Dairy Queen. The girls have a song, "You Were Drunk and Mean at Dairy Queen." Booth told me he slowed down when Miller approached. Window was slightly lowered and he told Miller to get away from his vehicle. Grabbed him and tried to punch him in the eye. Should be noted that Miller at the time of the arrest was a .22, which sort of explains everything. Mr. Miller, how did you even happen to be out here in St. Joe County back in February of 2022?
I was dating a woman out here.
All right, how'd you end up drunk and mean at the Dairy Queen?
Your Honor, this is a no contest plea.
All right, I guess you're right. I'm just curious.
It was a very bad day for me.
All right, I guess we'll leave it at that. Your previous lawyer was our old friend, Melissa Halleck. Let's see how much jail time you got. You got arraigned. Then you failed to appear. And they issued this warrant for you a couple of times. All right, I'll try it. Thanks. All right, this happened on February 21st. Oh, that was through a bonding company. I don't have any money. You posted the bond the next day. I thought I had some money in here to use. What do you do now, sir?
Go ahead.
It doesn't really,
All right, but you've been here. Well, you blew it off several years ago, and then I kept renewing the warrant every year, and eventually you came in to take care of this, which is a good thing. So I recall the warrant for your arrest. Prosecutors recommend fine and costs and time served. And I don't object to that. Apparently, I don't even know if they even have any victim input. This is a no contest plea. One day jail credit, 1 day. A $100 fine, $75 crime victims' rights fee, $50 state minimum fee, and a $150 attorney fee. That's $375. Do you want me to give you a date for that, or you want to set up a payment plan?
yeah, I can pay that today.
All
So
right, very good.
thank you.
All right, that brings this matter to a close after almost 4 years. No warrant hanging over your head, no additional jail time. It will show as an assault and battery on your record, but there's no firearm restriction for that. The bailiff will take you out to the court office. You can pay the fine. And,
Thank you, sir.
all right, good luck. How about if you don't come back?
And Your I'll circle back on the other ones.
All right, do you still have some others pending?
I have 1, 2, 3, 4. I know one is here, but I haven't checked the hall.
All right, well, we've got all morning. Thank you.
You want me to take those two, sir?
Sometimes I give them to, no, let me keep this.
Okay.
These are all last pre-trials. Ms. Montauk, good morning. What do you have for me?
Can I ask you just a question?
Yes,
I have a case that's going to resolve in 2 civil infractions. I just want to make sure then he could accept responsibility today. He gets the fines imposed today and we're done with the case today.
yes, who is it?
It is Anthony Roof. So the misdemeanors will be dismissed.
Reckless driving, leaving the scene of the accident will result in a plea to 2 civil infractions.
Yep, to an impeding and a careless. I'll go get the paperwork. I just wanted to make sure that it would all
Yes,
be done. today.
impeding is $100, carries no points. Careless, I think is $160 and carries 3
Great
points. So,
Okay,
all right.
all right, thank you. I'll be back in a minute. Thank you.
Mr. Taylor, we don't see you much. We've been seeing your brother. I haven't seen,
I'm filling in for him today.
all right, I haven't seen your alleged father or other brother for some time. Which case are you here on?
I am here on Laura, myself.
Miss Mysel, would you come forward? Good morning.
Morning.
You can pull this stuff right here real quick. We're just gonna.
This is file 252281, 2291 SD. You've been represented or are represented here by the Taylor Law Firm. Mr. Peter Taylor is here with you today. You're charged with operating with a high blood alcohol level. That's alleged to have occurred on November 9th. Not a lot of time has passed between November 9th and now. So there is a plea offer to reduce this to operating while intoxicated first offense. Mr. Taylor, at this point, are you going to ask for a final pretrial?
We are, Your Honor. We need to complete some discovery, get the body camera, dash camera from multiple officers, copies of the photos, and she also is scheduled for a substance abuse assessment on September 9. So we need to get that completed so she can follow up on some recommendations.
Is there a lab report or anything pending, or is that?
No, it was a breath test case.
So this isn't uncommon that we don't necessarily resolve it at this first hearing. In fact, we may not resolve it at all, but most law firms, particularly this one, is very careful about getting they want to see the video. More people ought to do that. But anyway, they want to see what the evidence is before they advise you on how you should proceed. So we'll set this for what's called a final pretrial. That'll be on a Thursday afternoon. Let me see. I don't believe you owe me any money.
I mean, there shouldn't be. I mean, she's on bond. She's been arraigned on it at this point.
No, people often have an old unpaid ticket or something that they forgot about. But it doesn't appear that that's here. That's why I always want to talk to everybody. I'm not doing very well. This case isn't in there either.
Are you guys gonna get on the one court
Eventually,
system?
here it is. Well, there are different, I've got it.
I need to refresh.
Okay. I started here, my first ever meeting as a judge was in November of 2002 after I got elected. And they said, we're trying to get all the courts on the same data management system. That was 24 years ago. I'll be gone before they actually get it done. But yes, they are working on getting all the district courts on the same, in fact, all the criminal courts on the same
Because
system.
they have, most of them are published on the one court system, but this
we're-
one's one of the only ones that still has their local system only.
Well, we have several. We have the old JMS, Judicial.
Oh, okay, you guys gotta quit switching up on.
I literally did it because you said that yesterday. So I just thought it'd be funny, but I'll go back. Good morning, Your Honor. Ashley Londi Feltus for the people. Your Honor, at this time, the people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that a
Good, see you. Go ahead.
Just when anyone does, we also wait.
In the court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder to the extent that conflict does exist, given the waivers, the court will consent to hear the matters. Are they ready to come on? You called them. Try to get this one done. Court does call the case of the people versus Mohammed Day.
Ashley Feltus for the people. And Assistant Public Defender Natalie Pate.
Big that dog, nigga.
Mr. Deanne, please keep yourself quiet in the courtroom.
You're
Assist-
fired. Conflict of interest. I'm a blood too. Can I get the fuck out of here now? She's fired. I would like to schedule for, get the fuck off my case. You're fired. You're fired. I'm not playing to shit. You're fired. With the ugly ass, dusty ass. So I'll represent myself. We can schedule for trial. When's your trial docket, please?
Well,
Conflict of interest. She's ugly and she got a dirty ass suit on.
Hang on.
Get the fuck off my case. Where your wig at? Where's your wig at? Where's your fucking wig at?
Dan?
Suck my dick. Let's go. Let's go, bitch. I'm out of here. Can you suck my dick right now? All the boys outside, suck my dick or warrior dick.
Yes, Mr. Dan.
Three times high roll.
Mr. Dan.
Thank you.
Big red
Take him out.
Spread your booty cheek so me and my nigga put my dick in. That's why you got two cheeks, bitch. Fuck a bitch. Why you wonder why they call you bitch? I bet you. You got two booty cheeks, one for me and one for my nigga.
I apologize to the court.
Why? Did you have anything to do with that?
No,
Oh,
but I still apologize to.
Yeah, but no, you don't. Yeah. I,
To reauthorize this felony as stated on the stage.
yeah, so it's coming back to me.
Yes.
Thank you for the apology, Miss Pate, but you really didn't need to apologize. I knew what I was going to be starting my date with. So this case, that case is, if in case anybody didn't hear, the misdemeanor is dismissed. And so after that, I'm done.
Tool. All right, this all makes sense. Sorry that it is a bit cumbersome, but we're gonna reset this for a pretrial after your lawyer gets more information. And that will probably be in January. We'll work that date out with Mr. Taylor's office. Or anything further?
No, nothing.
All right,
Thank you.
Mr. Gibson, have you got something for me?
Tony Booth and the prosecuting attorney.
And I'm getting one for you. Man. They'll be calling CFP and we'll have to go through an evaluation. It'd be a mess, so maybe not. I'm all set. All right. Court does call the case of People versus John Rice-Savvy.
Morning, Your Honor. Dan Guerin on behalf of Mr. Rasavi.
The Rasavi.
We've got it wrong every time, don't we?
Yeah.
You do it.
Risavi.
Risavi.
Yep. Say it. Risavi. Risavi. Okay, I'm not gonna do that. All right. There's a waiver here.
There is, Your Honor. Thank you.
All right. Sir, you signed this waiver of trial by jury?
Correct.
You understand that you have an absolute and constitutional right to have the matter tried before a jury?
I do.
You understand that by signing this form, you're waiving that right to be tried for the court without a jury?
I do.
You've also waived that right?
Yes, Your Honor.
Based upon the statement of counsel, the defendant court will consent to have the matter tried before without a jury. Non-jury trial. This matter will be set for
December 29th at 9 a.m. Your Honor, could we potentially get it?
no. Yes.
January 26th.
That's so nicely. You really did. I didn't want to. What time? When?
January 26th.
Will that work for you, Mr. Gay?
Yeah, well, Your Honor. Thank you.
January 26, 2026, 9 a.m. That's an in-person proceeding. All right. Thank you, Bond. We'll continue. Court does call the case of the People versus Michael DeWitt.
Actually, thought this for the people.
Morning, Your Honor. Dan Guerin on behalf of Michael DeWitt.
This is a malicious. Yeah.
Michael DeWitt.
All right. I have before me a plea form that indicates, and I guess he's going to be pleading. Since I got a police report and read it, that's a no contest plea.
That's correct, Your Honor, due to potential civil liability.
I'll mark the form here. All right. So the plea form indicates that the defendant will be pleading no contest to the charge of malicious destruction of personal property, 200 to 1,000, the 1-year offense. On his successful plea to that charge, well, that's as charged, correct? All right. So he's going to plead as charged, and that there is a sentence agreement of the prosecutor's deferred sentence. That's court's full understanding of it.
Ours as well, Your Honor.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Help you God.
I do.
What's your name, please?
Michael DeWitt.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased 3 times the value of the property that's destroyed or otherwise injured. If that's greater than 2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
All right. The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
All right. To that charge, how do you plead?
No contest.
All right. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
All right. And of your own free will.
Yes, Your Honor.
All right. Court has been provided Pittsfield Township Department of Public Safety report for their case number 2513562. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Sir, I do have to advise you, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first of all, you would not be entitled to withdraw your plea. And secondly, the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
You are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report consideration of the deferred sentence. Sentencing in this matter will be January 14th, 2026, 9 a.m. in the middle of my drive.
It is. You've gotten permission.
Nobody.
My apologies.
No, it's not. It's not your fault. It's Garrett.
Of course.
All right.
Yeah. Your Honor, I had previously given my client permission to travel, and I think that was sentencing date is when he was going to be gone.
Yes, I did, because I indicated he could travel there or something.
That's right. Yes.
The 6th through the 29th of January. What's my next day? Don't tell me that today.
January 28th.
That's not gonna work. He's coming back the 29th. Because Garen was about to yell.
How about February 11th?
Does that work? All right.
Yes.
Sentencing February 11th, 2026, 9 a.m.
Thank you.
Bond will continue.
Thank you. Does he stop at probation this morning? Your Honor?
Yes.
Okay, sounds good. I'll take it on.
Just start the process.
Thank you.
All right. Thank you, sir. And safe travels on your journey.
Thank you, sir.
This court does call the case People versus Timothy Reed.
Alexander, on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Reed. Mr. Reed, state your name for the record, please.
Timothy Reed III.
And Your Honor, at this time, people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice on defendant's motion. Thank you. All right. Thank you.
Thank you.
I'm gonna have nightmares about where's your wig. I really am. I can't get it out of my head. Court does call the case People versus Tez Faldet. You said Araya.
Alexander, on behalf of the people.
Morning, Your Honor. Dan Garen on behalf of Mr. Araya. Yes, can you state your name to the judge?
That's Valdez Araya.
Your Honor, I've spoken to Ms. Alley on this matter, and oh my God,
Miss Allie.
I'm having one.
Really? This is what I'm gonna call her the rest of the day.
Yeah, and she had to check her bar number earlier, and Your Honor, we're asking for an adjournment on this matter. There's no interpreter here. There has been an offer extended. I'd like to meet with my client and an interpreter to discuss that.
And we were unable to find an interpreter. Correct. That's correct. All right. I will adjourn the matter to jury final settlement conference to February 6th, 2026, 9 a.m. Jury selection, February 9th, 2026. 8:30. All right, and I'll just put there was an interpreter issue. All right.
Thank you very much, Your Honor.
The court does call the cases of the People versus BJ Pudell.
Gosh, felt this with people that matters.
How many does he have?
A lot.
Okay.
Dan Garrett on behalf of Mr. Pudell. Could you state your name?
BJ Porter.
Represent this morning to final settlement, both these matters, the people are unable to proceed on either.
Motion to dismiss on both, Your Honor.
People being unable to proceed. These cases are dismissed on defendant's motion without prejudice. Thank you. Court does call the case of the people versus Kurt Richelin.
Ashley Beltis for the people. And Assistant Public Defender Natalie Pate with and on behalf of Mr. Bushlane.
State your name, sir. Kurt Bushline. Thank you.
Your Honor, we are set this morning for final settlement. This time the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Aureli de Leon Cifuentes.
Alexander on behalf of the people.
And Assistant Public Defender Natalie Pate with and on behalf of my client who is approaching. Please state your name for the record, ma'am. Aureli de Leon Cifuentes.
And Your Honor, at this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Amin. Yes.
Alexander on behalf of the people.
Don't know why. It's all really simple. It's right in front of me.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Falahi. Mr. Falahi, state your name for the record, please.
Well,
Your Honor, at this time, the people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice. All right. Thank you, sir.
Thank you.
Court does call the case people versus Malik Lester.
Alexander on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lester who is approaching. Please state your name for the record, sir.
Malik Lester.
That's how you practice.
And Your Honor, at this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
sir. Court does call the case people versus Martinez Stewart.
Alexander on behalf of the people.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Stewart who is approaching.
Your name?
Martina Stewart.
Thank you.
And Your Honor, at this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you, Your Honor.
Court does call the case people versus Christopher Minor.
Ashley Beltis for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Minor. Mr. Minor, state your name for the record, please.
Christopher Minor.
Thank you, sir.
Your Honor, today we are set for final settlement. The people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you.
Court calls the case of people versus Eric Burton.
Beltis for the people.
Kyle Padilla on behalf of Mr. Burton, who is approaching the podium.
Your name, sir? Eric Burton. Thank you.
Yvonne Webster. Your Honor, this time people are unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed as without prejudice.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you. Court calls case of people versus Michael Heed.
Beltis for the people.
Thomas Heed for the defendant who is approaching, Your Honor. State your name for the record.
Michael Joseph Heed.
Look nothing alike. I know, right? All right, what are we doing on this?
In receipt of a bench trial waiver document?
I have it, I have it.
Oh, no.
Oh, okay, I don't have it, so,
I think we're looking for a bench trial date, Your Honor.
all right. Mr. Heed, you signed this waiver of trial by jury?
Yes, I did, Your Honor.
You understand that you have an absolute and constitutional right to have the matter tried before a jury?
Yes, I do.
All right, you understand that by signing this form, you're giving up that right and it'd be tried before the court without a jury present.
Yes, I do.
People also, for the record, waive their right.
We have, Your Honor, yes.
Based upon the statement of counsel and defendant, court will consent to have the matter tried before without a jury. Did you want, before I just launch into a date, you want the December or January date?
I think Mr. Heed is unavailable.
Yeah,
Attorney Mr. Heed is
January.
unavailable for the December date.
Then I'll set it then.
Oh.
No.
Oh, goodness.
Non-jury trial in this matter then will be set for January 26th. 20 what?
It's a non-DV case.
Oh, I did that. January 28th, 2026, 9 a.m. Will that work for you, counsel? Yes. All right, very good. Bond will continue.
Thank you. Your
Thank
Honor.
you. Thank you. Court calls the case of the people versus Brandon Bovee.
Ashley Feltus for the people.
Okay. Now it's Shand. Here we go.
Good morning, Your Honor. David Shand, on behalf of Brandon Bovee, is approaching. Good
morning, Your Honor.
Brandon Bovee.
Your Honor, this time people are unable to proceed.
Motion to dismiss, Your Honor.
Being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
All right.
Your Honor. Thank you.
Thank you, sir. Court does call the case people versus Benjamin Kritzer.
Ashley Feltus for the people.
Morning, Your Honor. Brent Oshinsky for Mr. Kreitzer, approaching this fan.
Good morning, Benjamin Kritzer.
Your Honor, this time we are unable to proceed with the final settlement conference.
Thank you, Your Honor. Defense respectfully moves for dismissal.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you, Your Honor. It's a pleasure to be in front of you.
Thank you, Your Honor.
Court calls the case people versus Brian Maynard.
Ashley Feltus for the people.
Sherilyn Foster Tucker on behalf of Brian Maynard.
Brian Maynard.
Your Honor, this time people are unable to proceed with final settlement conference.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court does call the case of the people versus Safaria Steele.
Ashley Feltus for the people.
And Public Defender Natalie Pate with and on behalf of Ms. Steele, who is approaching. Please state your name for the record, ma'am.
Sapphire Victoria Steele.
Thank you.
Your Honor, this time people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case people versus Alfred Jackson.
Ashley Feltus for the people.
And this is Public Defender Natalie Pate with and on behalf of Mr. Jackson. Please state your name for the record, sir.
Alfred Jackson.
Your Honor, at this time people are unable to proceed with final settlement conference.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case people versus Angela Stoker.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Stoker. State your name for the record.
Angela Stoker.
Your Honor, I do believe we're looking for a bench trial date here in this area.
That is correct.
You have. All right, Ms. Stoker, you signed this waiver of trial by jury form?
Yes, I did.
All right, you understand that you have an absolute and constitutional right to have the matter tried before a jury.
Yes, I do.
And you understand that by signing this form, you're waiving that right, it'll be tried before the court without a jury present.
Yes, sir.
All right. People also waive the right for the Based upon the statement of counsel, defendant court will consent to have the matter tried before without a jury. You want the January dates, I'm presuming.
Well,
Okay.
I thought more about it and I will be gone on for the 22nd or the 28th. I will be out on leave the end of January.
So somebody else would come in and do it?
Yeah, Natalie already
We
said.
can't do that. Ms. Stoker shook her head violently. She shook her head violently and said that can't happen.
Natalie graciously already said she'd do it, but I would like to do the trial if the court has dates available.
Okay, so all right. See, Perny, it'd be nice if I didn't like her. It'd be really easy. I have December 29th, but I don't know if everybody would be ready to go. If not, I hate doing it. I find a date to do it so Miss Perny could be here to do the trial. So if the 29th is too soon or there's problems with the holidays, then I can go after that.
I can have 30 seconds, Your Honor. Sorry, Your Honor, you cannot. Didn't need all 30, needed like 80.
Why'd you ask for 30? All right. So you cannot do it that day?
I think it's gonna be too soon, Your Honor.
All right. So is this a non-DV?
Well, it doesn't matter at this point, right?
Wow. Wow, no, I'm sorry for asking to try to clarify things. Wow, good morning. What?
Yes, Your Honor, it's
Oh, so now you're gonna. Okay, so when can we give a time to try this?
So we could do Monday the 5th at 9 AM.
That would be perfect.
That'll work for you? Will that work for you? Mr.
January 5th. Yeah.
Will that work for the people? Just a minute, she wants more of her 30 seconds.
If we think so, Your Honor, if it's a bad day, I'll let everyone know as fast as possible.
Oh.
Let me double check with officers. Nope, we'll go for that date, see what happens.
Pardon?
The 5th sounds great.
Okay.
Thank you, Your Honor.
Non-jury trial will be set January 5th, 2026, 9 AM.
Right.
Bond with conditions will continue. Thank you. You're welcome, Miss Perny. And I was gonna do that because Miss Stoker was just like, she just was vehemently that it was not gonna happen. I'm sure it was no issue with Miss Page.
No, it wasn't.
No, I understand that, but you have fun. I got it.
Thank you.
We'll see you next year.
Thank you.
Court does call the case of the People versus Anthony Williams.
Alexander, on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Williams, who stands to my right. Please state your name for the record, sir.
Anthony Williams.
Here's your advice of rights form, sir. And he is signing, we have reviewed the advice of rights form together already, but he's just signing it here right now at the podium. Perfect. Thanks.
I have before me a plea form indicates the defendant would be pleading no contest to 2 charges. I believe it's the stated count 2 of assault and battery, the 93-day offense, and count 3, which is domestic violence, basically first offense, the 93-day offense. Upon his successful no contest pleas to those charges, count 1 would be dismissed. And there is a prosecutor and defendant agreed to a sentence agreement for count 2 only, that being the assault and battery, that would be under the prosecutor's deferred sentence and an agreement to no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
And that is our full understanding as well, Your Honor.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Anthony Williams.
Your Lions fan?
Yes, sir.
Good game yesterday. Finally. All right. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges. That's your understanding?
Yes, sir.
All right. First is the stated count 2 of assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
And also that you'll be pleading no contest to the charge of domestic violence. That's also a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of assault and battery, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. Court has been divided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-05177. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of both of these offenses. Sir, I do have to apprise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rule, you would not be entitled to withdraw your plea, and the court would no longer be bound by any recommendation or evaluation regarding sentence. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of no contest to counts 2 and 3, 3 being 2 and 3. Count 1, the DV second is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
January 5th at 1 p.m.
January 5th, 2025, 2026, 1 p.m. We'll continue. Thank you, sir.
Thank you, Your Honor.
Sir, on your way out, probation department's on your left. Stop out there and talk to them so we can get the process started. Thank you. Court calls case People versus Heather Wright.
Ashley Feltus for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Wright, who stands to my right. Please state your name for the record, ma'am.
Good morning, Your Honor. Heather Wright.
Thank you.
Your Honor, this one people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
I don't know if we're ready on Dietrich.
What was the name?
Dietrich? I believe we should go. Yeah, we're almost ready.
Okay, almost.
McCain. We are in the midst of fierce negotiations. I think it will be.
Okay, so that.
McKay. Ready on McKay?
What are we doing? Here what? Okay, that's fine. Court does call the case of the People versus Samara McKay.
Rob Down, Assistant Prosecuting Attorney, Down people.
And Assistant Public Defender Natalie Pick, with and on behalf of Ms. McKay, who stands to my right, please state your name for the record, ma'am.
Shamira McKay.
Unable to proceed here.
Motion to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you. Thank you.
I mean, okay. So I'll let them, but she's gonna be involved. So I'll step off and then we can get counsel back on the other matter as soon as there's. We'll deal with it. Court of standing reason.
All rise. Maybe see.
Thousand.
If it was. Okay, that's. Yeah, when did you do that?
I'm getting.
And when did you give me a copy?
She should have done for you with these.
All right.
What should, but one did.
What is the bond right now? On this, in 23 CR 1656, Carl Chopin. Let me. He may know, but I want the data from the.
$200,000
Okay.
with drug tax, with GPS and home.
Oh. Right now, the bond is $200,000. Dollars. The defendant is charged with a second-degree felony of aggravated assault with a deadly weapon.
He's been in jail 26 months. Remember?
Oh, there's a motion to revoke probation.
Look at this.
Yeah.
Yes.
That's not even
No,
on.
this is okay.
That's
What is it?
You got a probation.
I got a motion to revoke probation in 20-34712. What's that?
That was 220.
You're on probation.
What's that in there?
I think we handled that first, and now he's on trial, set for trial in February on the new.
What happened in that?
You went to state. You got removed. You got removed. How much time did you get?
12 by stage, yeah.
Oh,
12 months state jail.
12 month stage, yeah.
okay. So that's a conviction. So he's not eligible for probation.
No, Fury.
No, it's not. And he's, I mean, it's.
What other
have to be
conviction?
burned here.
What other criminal history?
Y'all got me going in three different directions at once. The first direction I'm going is trying to find the motion that the defense filed. The second direction I'm going is trying to tell you the answer about the motion to revoke probation.
I've got the motion to revoke probation. I just.
Well, I was checking to see, Judge, if the underlying reason for his revocation was this offense, because Mr. Chopin is one of those approximate 10 defendants that were involved in the gas station beat down at the Shell station that you have seen the video multiple times. He is one of the three remaining that is set for trial. The state has been ready at each occasion, and I was checking I want to know first, if the state was even given notice that we would be having this hearing. Two, whether or not his motion to revoke probation was because of this offense. So from looking at the motion to revoke probation, it did not have that accusation within it. So that's not the reason you're there.
And
If I go back, sir.
Whoever handled this isn't me, because this is not my writing on the motion to revoke probation. Somebody else did this.
I think it was done.
52nd District Court.
I think it was done next door, and we inherited this case because I wanted to have all the defendants that were involved in that particular matter.
So this motion is in the file. It's not pending as a pending event, but the result of the motion is that defendant was
probation was revoked. He was found guilty and sentenced and finally convicted of burglary of a building. And so that's a felony, which means you are ineligible.
I don't see where the defense notified us of this particular hearing, Judge.
It's not at that hearing. No.
He filed a motion to reduce bond on November 13th. And I ordered and then I ordered a hearing on it. What's the bond?
200,000.
On these facts and circumstances, we submit that is the least that is required to ensure that Jefferson County remains safe. This, as I said, the safety of the community is really important on this particular matter. Your Honor has seen the video multiple times regarding this particular incident, and Mr. Chopin is one of the key individuals in that offense.
I'm going to correct your motion to reduce a bond because it's inaccurate. I'm sure you stated that it's in other words, excessive and oppressive, and that because of its present amount of 250,000 to 50,000 is what you're asking, but the bond is 200, not a quarter of a million. It's so that will be noted. Go ahead. What do you want to add? It's your motion.
Just that he's been in jail 26 months pending a resolution of the case. I understand the court's position with the trial docket, but Mr. Chopin's family is anxious to have him home for the holidays, and we're ready for trial. And it would be perhaps more expeditious for trial to occur if he were on bond. He would be in a position to transfer it to another court for disposition. If he were on bond, they didn't know. He's not a flight risk. He's a lifelong resident. He's limited. I appreciate Mr. Ham's concern for the community in this case.
Well, that is an important aspect of a bond.
And I don't believe Mr. Chopin's criminal history is indicative of the capacity of violence.
What is his criminal history?
That was the third thing that I didn't get to. Thank you for bringing that up.
At least his felony criminal history doesn't.
We know he's already convicted. We've discussed it. That occurred next door. Shows he was convicted in January 2021 for the offense of unlawfully carrying a weapon.
Where?
Here in Jefferson County.
No, I'm sorry. What court is in name?
County Court Law number 2.
Okay, thank you.
He was given deferred probation and took its second on that offense that has been adjudicated at the Burger Building State Jail felony.
When was he placed on probation?
January 6th of 2021.
When was that?
Yes.
All ready, James?
Court's pleasure.
I'll take you up next.
Just sit and relax. Enjoy.
Revocation was on June 22nd, 2022. This offense was alleged to have occurred on October 1st of 2023. Question will be how long he went to state jail and when he got out, as far as that's concerned, Judge.
You're talking about on the Berkeley.
Yes, sir. According to these notes here, looks like he was released in March of 2023. So within 7 months, we've got a new offense that's alleged. And that's what I can tell from his criminal history here.
Probably indicate you're on it. Just, as I said, it's been 26 months. He's wanted to present his case to a jury and get this thing resolved as soon as possible.
So do I.
So it's a mistake.
Oh my God, I just, if anybody else has an idea of how, yeah, I'm at 600 jury trials. If anybody figure out how we can do 2 or 3 at a time, let me know. Because I'm happy to try that. But humans being the way they are, we can, and the way the rules of criminal procedure work, one trial at a time is pretty much all that's allowed. And I just.
If you were on bond, we could transfer this. Well, drug court or one of the.
So 1/3 of our docket is over there. And that's, drug cases constitute more of our docket in between hers and mine and felony report.
We could get this one, so maybe over to Judge Wortham.
Where?
Judge Wortham. Somebody else.
Well, you know that. He's very helpful. And that's where it ends, unfortunately. Because no one else is really able to do our work.
Well, being that as a mayor, we still would request to inside.
That's why I urge people, don't commit crimes. You won't have to wait in jail.
Judge, I know your frustration and I can appreciate defense position. The state has been ready, remains ready. This case is one that I have been asking that you keep the 3 remaining defendants together because of the state's necessity to gather these witnesses each time that it's set on a trial docket.
Together.
There are 3 remaining defendants out of the 10 that were originally charged in this offense that are seeking trial. So I'm trying to keep those 3 together so I don't have to prepare for trial in different settings with the different individuals. Well, currently, they're set in February. They're collectively all set together.
Can we try him next? Is there any reason the state is somebody other than him to be tried next?
No, out of the 3 that are remaining, I need to resolve all 3 of them, so it doesn't matter to me which one I do.
He's set in February. Especially set one on that day. Okay.
Thank you.
Thank you. But James, not here.
Ms. Ballard?
That was the most also changed.
Absolutely. Look at the first slide. So you could speak up. We can hear you good, but she has to hear you. So when you speak up, let she can hear you. Let's make it easy on. Raise the book of this. No longer. Well, you can compete instead of few phrases. Yeah, I do. I think I was real cool. I didn't need to know where I started, but you can see the sign.
2 cases, correct?
Yes.
There. We now call 23-41367, the state of Texas versus Kia Ballard. That's you?
Yes, sir.
Present with Mr. Paget, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
She does, and we certainly can.
In summary,
yes.
This indictment alleges that on or about September 20th, 2022, in Jefferson County, Texas, you committed a state jail felony of abandoning or endangering a child. It's like endangering a child in this particular case. Do you understand what you're charged with here?
Yes, sir.
If convicted of a state jail felony, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here?
Yes, sir.
An agreement has been reached between the parties where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length. $250 is going to be a fine. There will be terms and conditions of probation, which are normal and customary for the circumstances of this offense. It looks like another case, I guess that's a misdemeanor.
Transaction, Your Honor.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign the document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney whether the contents all true and correct.
Yes, sir.
State's Exhibit 1 is tenderly evidence and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charge and any lesser included offenses. You were giving up your rights to a jury trial.
Yes, sir.
And the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. Thank you. All true it states, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is pre-sentence report waived here?
Yes, Your Honor.
I'm going to follow this agreement, if nothing further, and I'll find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty, even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted
No objection.
to find you guilty beyond a reasonable doubt. I am going to follow this agreement, and instead of finding you guilty, you will be placed on deferred or unadjudicated probation, and the finding of guilt will not be applied unless you fail on probation. There will be terms and conditions of probation. The probation officer will go over with you. We're going to place you on probation for 5 years. You do well, it shortens to 1/3 of that.
Yes, sir.
You hear that?
That's 1 2/3. Some of the terms and conditions of probation will be a fine of $250. There will be a parenting class. That's a good program that really all parents, whether they're in problems or in trouble or not, could probably use as a good refresher, so that all the I's are dotted, T's are crossed on ensuring that the child's welfare is in the best interests of the parent. And make sure you follow these. If you fail, your probation could be revoked and you could be found guilty and sentenced up to 2 years in the state jail. There's very little. The parole isn't even part of the state jail system. So you get good time, but early release is rare. So that's really like 2 years, which is the equivalent of an 8-year sentence in felony court. So because you can get, unless it's a very serious case, you can get paroled in 1/4 of the time generally. So state jail felonies do have, even though they're limited, they still have their severity. But you can avoid all of that by doing the right thing and fixing this mess. How many children do you have? Okay. Who is this?
My niece.
Your niece.
Yes.
Okay. Well, you may plan to have children one day. And if you do, this is a good dry run. These are mistakes I'm sure you'll never make, and you'll be a better person for all of this. Please see the probation officer and good luck.
Thank you.
See you, pal.
And you.
Best wishes to your
Always
wonderful family. You
Mother-in-law.
do me the honor.
Mother-in-law's 97, still living at home by herself. You know, it's.
Mom's 93. That my God bless her. And, everybody got to go to see her. Who's combing your hair? She's always taking care of you.
My mother-in-law's coming with some dirty jokes when we can see.
Oh, really? 97? Still in dirty jokes.
She'll run one off after another. She just now got to where, yes, sweetie, put that over there. I'm coming with you. She just now got to where.
So how did these jokes begin? There are two elderly people walking down the road,
No,
and
she's a hoot. She can bend over and touch her toes.
Really?
Really?
Did she get back up?
She showers by herself, does everything. So 97.
Well, you know, that's the key is independence as long as possible.
And she doesn't want people there. You know, my wife goes over there every day. We're 3 minutes away from her, you know. So my wife cleans her house and, you know, goes over every day, but has to stand outside the bathroom when she's showering because she will not allow any help.
My mother walks a lot. She
really, you know, that's impressive.
Every day.
That's impressive.
And maybe it's 200, 300 yards.
That's very good. Really good.
A day. And she's been doing that for about 10 years now. And we think she's near Milwaukee. Now.
There's something else. That's all I got to say. Have a good one. Thank you.
Okay, we have a couple of cases here to dismiss. After Mr. Paget, I don't know, everything else is anticlimactic. On Mary Anna De Hoyos, cause number 24, CR 2104. Motion to dismiss is before the court. I'm signing it. Boy, it's hard to believe it's 12:15. It's December 5th already. Actually, it's hard to believe it's 2025. Weird. Time is going. But don't check if it can. I think it went that way. In a trap, a motion to dismiss is before the court 25 CO 1573. Case as well as this one. It's almost. It's going to be 10 years or 30,000. It is going to tell you in what she's first with all of them. Yeah, she'll I didn't review it, but Langston, what are you up to?
I'm talking to my guys right now. I'm trying to work some magic.
Carnac, do your work.
Let's see if I do. Hopefully, 20 years unauthorized.
Here.
There's a long position. That's the feelings. Oh, just well, he's but I see a lawful. Oh, you have a lot of use in it. But I see at least on my swear saying it could be. That's right. Okay, I'll be right back. Okay,
I've got Latanya Bryant Langston. Latanya Bryant 2, Latanya Bryant 3. 3 Latanya Bryants with Langston cases. Then I have an Adrian Jacob with Langston, and that's 2 cases. Then I have Christopher Kane with Langston Adams, 1 case. Lance Woodward with Langston, 2 cases on Langston Woodward. And then we jump over to case. I've got a Tiffany Butler, which is Mr. Moore. Is that Mr. Butler?
No, sure.
And she's from Mississippi, huh?
That's correct.
And she's here.
She must be tired walking over. Y'all are out of Houston, right?
I am.
Gary, you. Okay, good deal. Okay, what's this? This is state jail felony theft, right, everybody, on this one? They're worse. That one of those. Gary, these are These are state jail felonies, you know, this one's state jail felon.
That's my understanding, Your Honor.
And you got 10 seconds.
Yeah.
Well, the state jail felonies here, 10 seconds.
Okay, understood.
But you can always buy more time.
I'm counting down.
You can always use a check and get additional time.
I appreciate that.
You'll find these people are very reasonable. Generally speaking.
Yeah, I'm just wondering who you were looking at.
Yeah, I know. Yeah, I know.
Wait.
Thanks, Jimmy.
Psychology.
The guilty party admits guilt.
And my understanding review the problem.
Hey, Langston, I didn't know you had so many. You're gonna work things out today, right?
I'm working.
All right.
Trying.
Come on, let's do it.
I'm trying.
Yeah, well, some of these people could go home for Christmas, maybe.
I know, right? He said he'll do
I
it.
think they would like it. If possible.
I'm sure they'd like it. I know what I've got on my table.
The
They
jail
have
does have a
going on.
nice Christmas. The Christmas meal in jail is really good. But I'd rather have the Christmas meal at home.
The max. So good show, man.
No, that didn't come from me, they came from mom. Oh.
That's a good idea. Yeah, he ain't gonna take the max.
I explained that to them, had them on the phone and so.
Cranberry sauce.
gonna take them.
You like the jail or you make your own? Let me just say, I do like the jail. I can do you want. I can.
I was in a circle.
I do want
I said she's, cranberries in this.
And they're good for it. They're a good thing for it.
You pick them up and I'll give it to
Hey,
You say 12?
they're not gonna cost kidney stone.
All right, I need you 12. See what you say.
Cranberries don't cost.
Same JNA.
So there he goes.
Yeah, that's.
He's a blur.
Try to take it out.
I mean, I'm still gonna call her back to your mom and it's surgery. That's what they are. I'm losing about the.
Yeah. I'll say every little comment. Yeah, it was out of show. With office. You have one more set of the questions they had.
Yesterday, when I was sitting on Santa's lap, asking for Christmas gifts up at the mall, he shared with me that naughty and nice list from the DA's office.
Okay.
Oh, yeah.
Are you sharing it with us or do we have to live in suspense?
You know who you are.
Yeah,
You know which ones are the naughty ones, which ones are the nice
I
ones.
suppose that the issue that is awesome.
Yep, I read off all your names.
Oh, I know where I was, Judge.
There were some nods and some shaking of the head by Santa.
You see a 12. It'd be a chance to team right now.
Sure could hurry up, use that cold so I can light the furnace.
2 tennies a assignment.
Yeah, Joe, give me a second.
Well, Mike, you just might get your wish.
I know.
I think the cold's coming in a truck. Yeah, we're gonna.
Record should reflect we had a bench conference in this case.
Thank you very much for the bench conference, Your Honor. For the reasons stated at the bench, we are requesting an adjournment of the final settlement conference. We have discussed with the people. Then I also have a brief request as to bond when appropriate.
All right, do you think it's appropriate? I'll adjourn the jury final settlement conference and jury selection. If necessary, I'll adjourn the final settlement conference to February 6, 2026 at 9. Jury selection, if necessary, February 9th, 2026 at 8:30. Both of those proceedings, once again, are in person. Yes, Esteban.
Thank you, Your Honor. Ms. Dietrich has been on bond in this case since September of this year, and to my understanding has not violated in any way or has been alleged to violate her bond. She also has not failed to appear for any of her court dates. She's currently on a GPS tether, and she is asking that the tether be removed at this time. She's not asking at this stage for any of the other bond conditions to change. She is just asking for the tether to be removed, largely due to the fact of the cost associated with having to keep this tether on. So I'd ask the court would consider allowing that removal.
And people have, your position is you are opposed, but you're leaving it to the court's discretion.
Correct, Your Honor.
All right. All right. You, ma'am, you would understand that if I release you from the tether at some point, that the conditions that apply to you still would apply. You understand that?
Yes.
Yes. All right. What I will do is I will not release it today. What I will do is I will indicate that the tether can be removed 1 month from today on January 5th of 2026.
Thank you, Your Honor.
All right, ma'am. Thank you.
Thank you, Your Honor.
Court does call the case People versus Spidey McLean.
Ashley Dalton with People. And Assistant Public Defender Natalie Pate with it on behalf of Kane, who is approaching. Please state your name for the record, ma'am.
Clady McCain.
Clady.
Your Honor, there's an offer available to the defendant to plead responsible to 2 added counts of impeding traffic 257676B. In exchange for a court responsible to those 2 counts, count 1 would be dismissed. To my understanding, she does wish to avail herself of that offer.
So 2 counts of impeding traffic.
Yes, Your Honor.
Ms. Payne, is that what your client wishes to do?
Yes, Your Honor, that is our understanding of the agreement, and my client would like to accept that offer today for the civil infractions.
Do you admit responsibility to the fact that on June 30th, 2025, at the location in Pittsfield Township, that you were operating a motor vehicle impeded traffic on 2 occasions on that day?
Yes, sir.
Right. Court will accept the defendant's admission to counts 2 and 3. Count 1 is dismissed. Fines and costs of $360. That's $180 for each count. When can that?
Your Honor, I did discuss this, and this was the amount we expected it to be. Ms. McCain. No, Ms. McCain is asking if the court would consider allowing her to do a $100 a month payment plan starting in January. She's currently on a payment plan for a case that is now settled for, but she had involving her rent. I won't go into too much details, but something
involving her rent.
Yes, Your Honor. And so she's asking if she could start making payments in this case, $100 a month in January. She said she'd be able to make that amount.
Okay, but I just want to understand the full picture. Behind in rent, made an agreement, so you're actually paying your current rent plus you have an additional charge each month, right?
Yes, sir. Yeah.
That's where you are. Okay. And I would imagine that trying to do that, things are tight, right?
Yes, yeah.
Okay, let me ask you this then. How much is your monthly rent?
$850.
$850. And then how much, in terms of the payment plan, how much more are you having to pay each month?
An extra $300.
An extra?
$300 a month.
Okay. And that, how long is that supposed to go on?
Just until I pay off what's already behind,
Right, but
which is,
about how many months?
I would say, given all my factors, probably less than 6 months, it should be paid off.
Oh, so if you pay the 300, you're gonna be paid off sometime around May or June?
Yeah,
Is that?
hopefully before then, yes.
When you say hopefully before that, because you're gonna try to pay more,
Yep.
right? And as life goes, what's gonna happen is you're living, catching up on other bills that you had to let go because you were trying to pay the 300 to make sure you had a roof over your head and all of that stuff, right?
Yeah.
Yeah, it's a wonderful life, isn't it? All right, so here's what I'm gonna do. It's $360. I'm gonna order at $50 per month because I know what you're trying to do and get that paid off. And I won't begin that until May of 26.
Okay, thank you.
So let you try to get your housing all settled and you can worry about this.
Okay.
Fair enough?
Yes, thank you. I appreciate that.
Welcome.
What, Your Honor?
This is the last case. Who's left on the last case? Oh, man. They need a conference. Okay, court's gonna stand in recess. Can you take me out for a second?
Yes.
Yes.
In that final decree, there was a permanent parenting plan. There is a permanent parenting plan incorporated. Is that correct? That's correct. Okay. And in that, in section E, which is page 21 out of 28 of that document, it states that Mr. Perez was to insure his life in a minimum amount of $50,000. Is that correct? Yes. Okay. And said policies were to name the children as sole irrevocable primary beneficiaries, with you being the trustee of to the benefit of the children. And it also stated that you were to serve without bond or accounting. And Mr. Perez has passed away as of February 12th, 2025. Is that correct? That's right. Okay. Now, Mr. Perez did have a will. Is that correct? Yes, ma'am. And it stated in the will that if there was any trustee or trust naming the children as beneficiaries, that an individual is named Nancy Johnson and Kevin Johnson shall serve as guardians. Correct? That's right. Okay. But the children were not named as trustees or the beneficiary of any trust at any point. Is that correct? That's right. Okay. So Mr. Perez held 4 life insurance policies through Prudential Life Insurance for Devin and Briella. Is that correct? Davian and Briella. Is that correct? Yes. Okay. And Prudential Life Insurance isn't releasing the money to you unless a guardianship is established. Is that correct? You're asking the court to appoint you as guardian over the minor children's estate. Is that correct? Yes. Okay. And you're their mother? I am their mother. Okay.
Frankly, I never could tell very much about this other than the ticket. And also leaving the scene of a property damage accident. You're here with your attorney, Sarissa Montag. Also present is Mr. Luke Knopfinger, who is the village attorney for which village?
Centerville, Judge.
Howard had been appearing for Centerville. I'm a bit unclear, but he's okay with me as long as one of you is here.
There was a little confusion when the police departments joined, Judge.
I'll make a comment on that. The Centerville and Constantine Police Departments merged into one department. And Chief Thayer is doing an excellent job. And both Centerville and Constantine, I think, being very well served by that merger. Howard Bush has been the Constantine Village Attorney for years, and Luke Knopfsiger has been the Centerville Village Attorney. So you have the same department, but two different jurisdictions. So it's fine with me. Anyway, Mr. Ruth, you got a ticket here in Centerville. Again, I can't tell very much about it, but let's talk a bit about it. The worst of these is reckless driving. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 6 points and requires that your driver's license be suspended. The prosecutor has agreed to dismiss that charge to a plea to a civil infraction of careless driving, which is a much less serious offense. That's punishable. I believe the fine is $160 and it carries 3 points. The charge of leaving the scene of a property damage accident, that carries 2 points. That's been dismissed for a plea to impeding traffic. Impeding traffic is a civil infraction that carries no points. And it carries a $100 fine. So this is being reduced from 2 misdemeanors to 2 civil infractions. I'm sure your lawyer explained this to you, but a civil infraction isn't even a crime. It's a civil wrong that's punishable by a fine only. So you don't plead guilty or not guilty to a civil infraction. You simply admit responsibility. Mr. Knopfsiger, you confirm the plea offer?
Yes, Judge.
And you agree, Ms. Montauk?
Yes, Your Honor.
All right, Mr. Ruth, you're gonna admit to careless driving. I don't even need to take a factual basis. Is that correct?
Yes, sir.
And impeding traffic. Is that correct?
Yes, sir.
All right.
I make a couple comments, Judge.
Yes, thank you.
Yeah, I would caution Mr. Ruth. I suspect he was drinking and driving, but I don't have a way to prove that beyond a reasonable doubt. So caution him. He's very fortunate here.
Well, again, I'm very confused because this is a Constantine case, not a Centerville case, but you and Mr. Bush can, I guess, figure out who represents which village. Howard is usually here on the Constantine cases, but this happened on West Water and Cass Street in Constantine at 11 o'clock at night.
Judge, there was an email chain with Attorney Bush and Mr. Thayer. And so he said they had sent it to me. I said, what's going on here? I said, well, you can just take care of it.
Okay, fine with me. Both are qualified and you've done municipal work. So I don't really, anyway, it's fine with me, whatever works for the city. All right, the fine and cost for careless is $160. And the fine and cost for impede is $100. So the total is $260. Can you pay that today or do you need time to pay it?
I can pay that today, sir.
All right, I'll have your lawyer take you out to the counter. You can pay those civil infractions. You're going to get 3 points on your driving record. There's no mandatory suspension and it's not a crime. So that brings closure to this matter. And if you did dodge the drinking driving bullet, keep it in your pocket because you don't want to be there. So this may be a lesson learned and take it in that vein, and then you won't have to come back here for something worse. All right, you're good to go, sir. Thank you, Ms. Montauk. All right, what do we got here? We got some Truckee cases. Miguel Ramos Perez. Failed to appear. No, he is here. Let's do that one. Miguel Ramos Perez. Ross, your client's looking for you. Or move. All right, good morning, sir. Are you Miguel Antonio Ramos Perez?
Yes.
You got charged with assault and battery and assault and battery. In file 23819, and you got charged with driving without a valid license in file 2522310. I think when you got picked up on or cited on the traffic case, you found the old warrant for assault and battery. So let's take that one first. In the assault and battery case, the prosecutor is agreeing to dismiss the charge of assault and battery for a plea to disturbing the peace. I don't know if you were in here, but I said it earlier. Disturbing the peace doesn't matter who was right or wrong or who started it. Was there a quarrel, argument, or disturbance in a public place? It's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. The driving charge is going to be plea to having no license, and they're going to dismiss the registration plate civil infraction, which will save you $126, and no insurance, which will save you $150. So that's a pretty good deal. Is that your understanding, Ms. Strong?
Yes, Your Honor.
That's my understanding as well, Your Honor.
All right, very good. Those three charges often go together. No insurance, no registration, and no license. The prosecutor is dismissing the civil infractions. So let's talk about this old assault and battery case first. Anybody threaten you to get you to plead to that lesser charge of disturbing the peace?
No, Your Honor.
Or promise you anything?
No, Your Honor.
All right, let's take a look at that case. As I said, this was a 23 case. You kind of went off the grid for a while. There was a formal complaint that alleges that you assaulted Jordan Ash. No, you assaulted Calvin Mosier. 2 counts in Three Rivers on April 7th of 2023. You didn't get arrested on this till November of 25 when you got stopped. And you posted a bond of $200. So who is Calvin Mosier to you?
He used to be an old friend of mine.
And did you and him get into an argument that day?
No, I was breaking up a fight.
All right, as I said, it doesn't matter who was right or wrong or who started it. Was there a tussle in the street out there on 14th Street?
I'm sorry?
Was there some sort of scuffle outside in the street where you guys live on 14th and 15th Street?
There was, but it didn't involve me. I was breaking up a fight.
All right, so how did you get involved in this?
Because I came outside and seen that Calvin Mosher was assaulting somebody, and I went and broke up the fight.
All right, says, well, you jumped on him. That's close enough for me. And then when they stopped you for this driving thing, they served this old warrant on you?
Correct.
Had you moved from your address?
Yes.
All right, so they just found you by accident. Arrested on the 12th. All right, I'm not disturbing the peace. What do you do now, sir?
I work in machine and rotational molding, Constantine.
All right. Have you got your license straightened out?
No, I'm currently working on that.
I'm gonna order 1 day in jail, credit 1 day, $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. So that's $200, and you posted $200 of bond. I'm not gonna assess any attorney fee in that case. So that resolves that one altogether. Let's talk about the driving case. As I indicated, they're dismissing all these other charges, which is good. It's going to save you a bunch of money. I can't remember. You were born in Puerto Rico?
Yes, sir.
So you're an American citizen. There's no issues regarding residency status or any of that stuff. So that's a good thing.
And Your Honor, if I may, he did indicate that he has outstanding fines and costs with the court. He set up a payment plan today while he was here and made a payment. Now that he's working, he intends to keep up on those payments, but he did make a payment today.
Good. He has 2 other assault and battery cases, one in 2019, one in 2020, which he has not paid on. He also has another no valid license from 2019. It was $1,260. I can put him in jail and wipe all that out, but I don't really want to do that. But I don't like the fact that he blew this stuff off for years, particularly the 2 assault and batteries. When did you make your most recent payment?
It was today when I came in.
How much did you make today?
$90.
I would do the same thing as I did with the other ones and set this out for sentencing, but your lawyer is very hard to schedule sometimes because she's busy in other jurisdictions. So I'm just going to do a leap of faith that you're going to pay this. So let's talk about it. Were you driving a car at 7:13 in the morning, kind of on the boondocks, Centerville, Constantine, and Bergner Road? I'm guessing you were on your way to work. Were you driving to work that morning?
I was on my way home from work, Your Honor. I worked their shift.
All right, I think you might have told me that at your arraignment. Whose car was it?
It was my sister's.
She can get in trouble for letting you drive the car. Let's take a look at your driving record. Well, some of it is you got some other unpaid tickets. Your deal is you just don't have a license. Have you started the process to get one?
Yes, I'm currently working on it right
Tell me about that.
now. I needed to get my glasses first because they wouldn't let me do it. I already got that set. I started coming in. They should be within a week. And then after that, they told me to call up and make the appointment again. They'll get me right in.
Well, this is gonna show up on there. This could jam the process up a little bit. But you need to start it. There's nothing bad on here. I've got people that have got old drunk driving cases. That means they can't get a license. I got people that have got residency issues that can't get a license. You don't have any of that. You just need to do it. This is just no license, 257301. $100 fine, $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. I didn't assess an attorney fee in the other case. This adds up to $375 or 1,000 days in jail if you don't pay the fine. If you blow this off like the other ones, I'm gonna end up doing a show cause where I talk about going to jail to wipe these out. 1,000 days would be about 3 years. I can't really do that on a 90-day misdemeanor, but I'm serious. I want you to pay these. And don't get more of these because the prosecutor won't give you that indulgence. And your sister, did the car get towed?
Yeah, I got totaled completely.
Oh,
I was in an accident.
Oh, geez. All right, when you're in an accident, you don't have any insurance, you're gonna get sued by the other people's insurance company. You're probably tired from being up all night, so this ain't good on several different fronts, but I'll send you out to the court office. I want a payment plan with the kind where you actually make a payment. All right, good luck to you on your license journey there. You're good to go. Does that finish you, Ms. Strong?
Aside from the fail to appears,
All right, I think, did we make a record on those?
we made a record on Lucio Gomez Arias, but not Jacqueline Giselle or Nevaeh Horton.
All right, Matt, do you have those?
I do.
You
I don't have the paperwork. I gave it. I left it with me.
Well, let's get those.
And with that, I think were y'all.
Somebody may have been.
Reagan, that was cool.
When she got into
Yeah.
our custody, she was appointed.
A public defender here. And then y'all got in on it.
So one of the issues in this case, well, that's right now, I don't have everything I need yet as far as discovery.
What do you mean?
There's a video and audio that I need. It's a fairly complex case. It's not simple. The other thing is that there's a warrant pending for a co-defendant's case, which is a very important factor as to what happened there. So I would need a little bit of time to get to the bottom of all of it and have a sit down with the DA's office and figure out where we're going to be.
I'll stand by.
Yes, all.
This, we have to stay here until next week. That's why Einstein was asking, can we just leave it free there?
Who's on the prosecutor on this one? On their mother.
This was the Jacob.
Because it was Ms. Staub and then she's no longer.
We're in the middle.
Oh, I'm sorry, my bad.
No, just a second. Just a minute. Middleton. On the, where are we on? What's the state's position on this?
I let defense counsel know we offered today. So it's my understanding that he needs to request discovery still.
Okay, it's old. I don't know, it's old, and I'm just gonna put it on the trial docket and let's see where it goes, okay? And y'all get ready.
We'll figure it out, Your Honor. We'll get to the bottom of this and I'll work diligently.
Yeah, 2 years, it's over 2 years old, and it's kind of bounced around, but, well, I understand why. But with that length of time, we're gonna just throw it on the trial docket, but
We're in a best of that.
but I'm at 600 jury trials right now, so we can only try one at a time. And we've got 2 more before Christmas that we're trying, and then
I assume we would not.
we won't be ready
preferentially
before
set.
Christmas.
Right.
I guarantee.
Thank you, Your Honor.
Who's up?
Judge on
I forgot about
This man?
Kane.
That's up.
No, sir, Kane is in the back. We,
Who's your lawyer?
Guilty on
Langston.
Where's Lanston? That's what he needs.
That's not Christopher. Christopher's in the back. Christopher Kane is in the back.
No, he jumped out. No, I'm glad you reminded me on that. Yeah, that's about terrible.
Adrian Jacob?
Mr. Jacob, yes, sir.
You can't come. 2 cases?
Judge, we're going to be asking for a short reset on Kane. I've discussed an agreement with defense counsel and they're on board with it, but I do want to speak with the victim's mom before we set it in stone here before the court.
Okay, on Jacob, these are MTRPs?
I believe those are Mr. Boyd's.
Yeah. It looks like MTRP in each case. Well, that shouldn't be much of an issue. That's for me to decide. Let me do it. Y'all can't get an agreement.
They're working on it, Jeff.
He's been working on it a while.
If we use air quotes.
Okay. Okay.
That's really important. Your Honor, pleasure. Thank you.
You got everything done?
I did.
Okay.
Thank you very much.
Thank you.
Daniel, do y'all have an agreement on?
I think we will shortly. Yes.
On what?
Jacobs,
Mr.
Jacob, right?
Well, it's an MTRP. Y'all gotta, there shouldn't be, if y'all can't figure it out, I will. I'll do it.
Right, it's an announcement, but it's, I think we.
Yeah, these things, but it, it was filed in September. Yeah. And
Penny on Kane.
It doesn't even, do we have something next week?
Yeah, next week is fine. It doesn't have to be in Monday's job.
Well, Mr. Bonner, he's still 8 years, right? All right, so I don't know if you asked me what you did probation. I said, I know it's just.
so, so on Jacob, Adrian.
He's ready. He's gonna plead today. We come with today.
That one. What else do we have? I've got LaTanya Bryant.
Okay. Yeah, that's
three. That's 3 cases.
Yes, sir.
What are we doing on all those?
She's in the back right now, and I told her
in the back.
She's saying no to the 8 years.
Well, they all say no to 8 years. I wouldn't say yes to 8 years, but that doesn't mean it's not the right thing to do.
But we did have another case to plead.
Here's the. Okay. All right. Well,
I signed Kane up, but you need approval, right?
Say that again.
No, I'll tell him. He's asking me what we have. I told him we signed Kane up, just need approval, and if we get approval, it'd be good.
Yes, Ellie, are you available next Friday to come back? She said she already did the Monday documents are done.
all right.
Do the following then, because next Friday we out of town.
11.
This.
Yeah, so do the next following Monday.
The 15th?
Yeah, Monday.
Okay.
That'd be perfect.
Okay.
Not Friday, Monday.
I forgot you're out.
On Bryant?
Yeah. Montgomery.
Okay. Let's get.
That's right. He's right. That case gonna be moved today.
Latanya? No, I'm talking about Bryant. What are we doing?
Oh, Brian, she's saying no.
Bring
So I
her
said let's
out.
put her on the
Let's get
trial.
her out so we can move that one aside and then we can take care of the others. Okay? Thanks. Because.
But now, what's his name is gonna be a plea. Kane is gonna be a plea, just not today.
Why not today? Why not?
She has to get permission from her victim. I already did the paperwork, but once she gets.
Call her up.
I called Judge, I didn't get an answer. I sent her a text message, so I've been checking my phone, looking for a call. I haven't gotten one. I'll try one more time.
Once she says yes, well, it's already signed. He signed.
We got so much going on before the holidays, and we don't have time to push anything back. If we can get something done, let's get it done because it's good. It's going to get jammed together within the next 2 weeks. We're almost up here while everybody else is at home for Christmas. And we're up here at Christmas Eve.
Well, I know.
Come forward.
It's all signed up. It just wasn't on.
Are you Latanya Renee Bryan?
Yes, sir.
Okay. I have 3 cases. By the way, you're here and Mr. Adams is your turn. There are 3 indictments here. And in well, this in a sequence. It looks like a 25 CR 445 is the first one in sequence. And this that's odd. They're indictments on different days. First indictment, April of this year, you were charged with a 3rd-degree felony of collision involving injury. And it is a 3rd-degree felony, which carries with it up to 10 years in prison. But in this indictment, as well as all the other indictments, the other 2, the grand jury included in the indictments that you have prior convictions, 2 of them on 2000 and in 2009 out of the court next door, the 252nd District Court, for 1 for aggravated assault and 1 for delivery of a controlled substance. So if 1 or both of those were proven true, it moves or bumps up the charge. In this case, a 3rd-degree felony, it becomes a 2nd-degree felony. You're looking at up to 20 years in prison, and you are not eligible for probation in front of a jury. In 25 CR 885, this indictment handed up on July of this year alleges that you committed the 2nd-degree felony. God bless you. Of aggravated assault with a deadly weapon on or about June 17th, 2025. And if convicted of this, it's a 2nd-degree felony, but which carries with it up to 20 years in prison. Okay, over there?
Yeah.
And because of the prior convictions that are alleged, the same aggravated assault and delivery, if all of that was proven true, you were looking at life imprisonment if found guilty of that. Excuse me. Look at something here. God bless you. Oh. There's a third indictment, 25 CR 1110. Which was an indictment handed up by the grand jury a month after the aggravated assault with a deadly weapon. And it alleges that you committed the third-degree felony of evading arrest or detention with a motor vehicle, and those prior convictions are also alleged. So if you're found guilty, it becomes prosecuted and punished as though it were a second-degree felony, up to 20 years in prison. Stand.
Excuse me.
Is it,
Things that show you so the residents get. And for this thing, please, how many have that claims?
So those are the three cases, which is which equals in all of these to two second-degree felonies of 20 years each, 40 plus first-degree felony punishment of up to life imprisonment. And what are bonds on these? But most importantly, what's the bond on the 885 and 1110? You don't want. They must be high. You're in custody. You hadn't been able to post a bond, and I think I know why.
30,000 plus no contact plus GPS remaining in Jefferson County.
For what?
The 0885. I assault with deadly weapons, 30,000. You said the 1110?
Yes.
10,000 with.
Who said that bond?
I have to look at it.
Okay, it wasn't me.
No, sir. The JP in the time, who's ever out of the jail.
They must not have had any clue about
Each one.
this first case that had been indicted, because you posted a bond in this first case on, or a bond was set by the magistrate on April. Then looks like there was a hearing on in May of 25, where the defendant it says
It's a forfeiture.
she wouldn't cooperate with the magistrate. So she was indicted and posted, and a bond was set in May. The next month, it's alleged she commits aggravated assault with a deadly weapon. And then that on 6/18/25, they take up a bond hearing. And then on June, I guess she's released because in a week, she's committing a third offense of evading arrest or detention. She doesn't have a bond, does she?
The 445 is 16,000.
No, there is no bond. No, you don't have a bond. It is all revoked. You committed an offense, post a bond. A few weeks later, you commit a second-degree felony of aggravated assault, according to this, and post a bond. A few weeks later after that, you commit a third crime of a second-degree felony. And you are too dangerous to the community, and you're obviously you're going to stubbornly refuse to follow any bond conditions, which include the first thing, don't commit a crime. So you're not getting out until we can try these cases. We're going to try the most serious one first, get this first degree felony out of the way, okay?
Yes, sir. Yes, sir.
Anything, Dan?
Yeah.
That's the rulings of the court. They don't get ready. Everybody, we're going to move this fast. All right, you have somebody, let's go. Who is it, Christopher?
No, Christopher's the one that waiting on the, it's Vic, you know?
Okay, who is it? Smith?
This one is Mr. Adrian, Jacob. He's ready to go. It's an MTRP, and he's pleading true.
And two cases are now called. Cause numbers 23 CR 1411 and 23 CR 1838. Motions to revoke unadjudicated probation in the cases of the state of Texas versus Adrian Jacob. You are Mr. Jacob.
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. Does the defendant waive formal readings of these motions of to revoke unadjudicated probation in 1411 and motion to revoke probation, which I guess was regular probation, in 1838? Can we proceed in summary?
Yes, sir.
Okay, I don't see any agreements.
He's gonna plead true and he's gonna go to you, but the state is gonna make a recommendation.
All right.
The state is gonna make a recommendation.
And in summary, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? Sit up, you guys. Lower your hand. In summary, 1411 states that on March 31st, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for the second degree felony of aggravated assault with a deadly weapon. Is all of that true and correct, sir? Allegation 1 states you committed the offense of theft on or about April 6th, 2025, which would have been a week after you were placed on probation?
Mm-hmm. Right.
In violation of your probation order here in Jefferson County, Texas. Is that true or untrue?
Yes, sir. He says true.
2, you failed to report to the Jefferson County Probation Office since being on probation on March 31st of 2025. Were you arrested earlier on this, or was there a period of time that he did not report until he gets arrested? How long? You were supposed to report monthly.
Yes, sir.
And did you fail to do that?
Yes, sir.
When did you finally get arrested? Do you remember? I would. It would be important to me.
I got arrested on October 3rd.
October. Okay. So you were supposed to report, you were placed on probation on March. So you would have had to report April, May, June, July, August, September, and then in October you get. So what's that? months go by that you didn't report. Is that true? About? It's 6 or 7 months.
Yes, sir. Yes, sir.
Oh,
Yes, sir.
so is that allegation true and correct?
Yes, sir.
I'm going to stop at that. Okay. Are you pleading true to allegations 1 and 2 of this motion to revoke probation voluntarily, knowingly, intelligently, and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced no less than 2, no more than 20 years confinement in prison, since this is a second-degree felony. Knowing, understanding, and appreciating all of that, do you insist on pleading true today to these violations?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to violations of probation.
Yes, sir.
Let's hold that in abeyance. Okay, go to 23 CR 1838. Again, does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
And again, you're under oath, sir. In summary, this motion filed on September 29th, 2025, as well as the previous motion, it states in this other case that on March 31st, 2025, the same day you were placed on probation in the aggravated assault with a deadly weapon, second-degree felony case, that you were sentenced to 2 years in this court in the state jail, probated for 5 years for burglary of a building. Is that true?
Yes, sir.
And allegations 1 and 2 are the same. That number 1, as before, the previous case, you committed the offense of theft on or about April 6, 2025 in Jefferson County, Texas, in violation of your probation condition 1 and 2. You failed to report to the Jefferson County Probation Office in violation of condition 4 of your probation supervision order by absconding in April and not being arrested until several months later. Or allegations 1 and 2 true as well as they were in this previous motion to revoke probation?
Yes.
Are you pleading true to allegations 1 and 2 as well in this case?
Yes, sir.
Are you doing that voluntarily, knowingly, intelligently, and because this is true,
yes,
as it is alleged? And again, do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation could be revoked in this case, and you could be just sentenced to no less than 180 days up to 2 years in the state. Yeah.
Yes, sir.
Knowing that, do you insist on pleading true as well today?
Yes, sir.
I find you are pleading true voluntarily. In each of these cases, you understand and appreciate the consequences of pleading true and how that might make you vulnerable to revocations of these probation orders in each case. There is no agreement in each case?
Well, we come to you.
All right, go ahead.
Judge, I know that you just pointed out specifically the time.
I'm going to look at the pre-sentence report while you're talking, okay?
I noticed you pointed out the time frame from the point that he got on probation to the point of this violation. But I think we're asking the court to take into consideration why it happened so fast. He was homeless, and talking to him, the object stolen, it's not like he was stealing a car or going to steal something major. To my understanding, it was buckets of water, not buckets, but bottles, cases of water. And the reason that he was getting that water that he was stealing, Judge, is that he was destitute and homeless at the time. Yeah. At the time, he was destitute and homeless. And Judge, we're asking you to have mercy on him because, like I said, this is not a situation where you got a guy going into dealers and let's say he's stealing a bottle of cologne and resell it. And I totally get that. But this is a situation where he was destitute, he was homeless, and it was for his needs, his bodily needs, which would be water and cases of water. And Judge, I spoke with the prosecutor on this case as well. What I'm asking is that if you just give him one more shot, leave him on probation, I do believe to get him out of the hole that he's in terms of his economics, he will be able to get a job, right? I have somewhere to stay then. And he has a place to stay, and I believe some of his family members are gonna step up this time for him. Yes. So just looking at the nature, and he's accepted responsibility on the theft case. Yes, sir. On that theft case, Judge, if I'm not mistaken, and you can look at your file, I believe the misdemeanor court put him on probation for that theft. So in the misdemeanor court, they gave him probation. And who was your judge on that? That was Holmes. Mm-hmm. Yeah. Okay, yeah, I believe it was Judge Holmes. Yes, yes, so, Judge, what we're asking for is for you to continue him on supervision, move the case today, and consider his economic situation at the time. And that's why it happened so fast. And also consider the object that was stolen was not an object of, personal gratification. That's what he's telling me. At least that's what he told me. Okay.
So
that's what he told me.
But he was placed on probation for
that's what you said you told me. Cases a lot. That's what you said.
in 1411 that the defendant broke into the victim's truck, and that then he was armed with a knife and cut the man, is what he's alleged in this aggravated assault with a deadly weapon.
Yes, sir.
And
the other one was the MTL people further the building.
He was later arrested for the stabbing incident and indicted and placed on probation for that aggravated assault of March 31st of 2025. In September, they've released go again to Crystal Apartments on Gulfway Drive. 2 blocks away from the previous incident. And on September 5th and 23. And go to a theft that's reported where the victim reports that he stores industrial and commercial paint sprayers in a storage building, and surveillance video was acquired by the police who show the defendant and another person stealing those items as they are in a Chevrolet sedan with no license plates on the front or rear of the car. They back into a spot. He and another person get out, steal the sprayers, then take off. And then Mr. Jacobs apparently is known by the Port Arthur Police Department, and he was recognized. And that apparently that there were two thefts of the sprayers on the same day at that same location. And police find the defendant, Mr. Jacobs, and he admits being involved with it. And so he's placed on probation in these two cases of aggravated assault and burglary of a building. He's placed on probation and given another chance in spite of the fact that he has how many prior felony convictions of burglaries and forgeries? How many? So, because I know, there's so many, I want to know if you can recall how many you have been convicted of.
I can't say.
You can't even remember. What does that say? I know of 7 burglaries of homes and back to 91, a burglary of a habitation, somebody's home. 3 years later, you're convicted of another burglary of habitation. You get 15 years in prison. Then in 94, you're also sentenced to burglary of a building, 15 years because I guess it was enhanced because of the prior conviction. In 2000, another burglary of a building, 3 years in prison. Forgery in 07, a year in jail. Burglary of a building in 09, convicted 6 years in prison. Then in 23, you were convicted of burglary of a building in January of 2023. So those are the felonies. And let's not forget, I'm looking at a page full of misdemeanors, which are deep driving while license suspended, driving while intoxicated, theft, burglary of a building, of a vehicle, burglary of a vehicle. Anyway, so those are 4 convictions of misdemeanors, 7 convictions of felonies. And then now we have these 2 revocations. We're back. And it's as though everybody is spinning our wheels. I mean, you're not only continuing to commit a crime, and you're not reporting. And hold on, let me just, this, you keep talking about water, but the administrative hearing doesn't say that, Langston. It says that on April 6th of 2025, the date that this theft occurred, allegation 1 that he is admitted to, it states he committed theft on or about 4/6/25, stealing someone's wallet containing about $1,000 in cash, a debit card, and insurance cards at a local HEB grocery in Port Arthur.
He said, right, and Judge, I talked to him directly. He's saying that he had nothing to do with that. He's telling me that, didn't you tell me it was water? Yes, sir. I heard him correctly, Judge. He told me that it was water, and he was stealing because he was destitute and he needed bottles of water to drink. Is that what you told me? Judge, that's what he told me.
That's what the administrative hearing states is what this is. Okay. So now I've got a police report to look at your standby. On April 6th, there's on arrival on 4/6 at 9 p.m. Officers respond to Gulfly Drive at the HEB, made contact with the manager who advised me one of the customers had her wallet stolen. I watched the video footage from the store, and then the video shows a male black approaching the victim near the produce area. She had her wallet on top of her cart. The suspect is observed walking toward her shopping cart as she's getting some produce. Facing away from the shopping cart, the suspect reaches for the wallet, which is on top of the shopping cart, and continues and then conceals it in the pocket of his sweatshirt. The suspect left the store shortly after, got in a passenger front seat of a dark green Chevy Trailblazer with no front license plate. The victim I was advised the victim had $1,000 in cash or debit card, as well as an insurance card for her children. She did wish to press charges. I spoke with the manager. Manager advised that the video had already been tagged, and then that's all it says on that. On April 8th, 2 days later, Detective Thomason with Port Arthur PD receives the case for follow-up investigation about the HEB theft. Let's see. The surveillance was played, captures the suspect taking the wallet, provided me Ramirez provided me a video and printout of the transaction. The name, let's see, the surveillance was played back. It captured the suspect taking the wallet. The suspect is a light complected African-American with short hair. The same male bought items and used a card. Investigator Ramirez provided me the video and a printout of the transaction with the male suspect. The name on the transaction is Adrian Jacob. I am very familiar with Jacob. I've known him for many years through my employment as a police officer at the city. I personally filed many cases against him. I reviewed the video. There is no doubt the suspect is Jacob, not only by his face, but he has a distinctive limp and is noticeably bow-legged. All right.
So you told me that it was water. Right? So I guess the question the judge is raising is that based upon what he read, was that you?
Are you pleading true to these or not?
Yes, sir. Yes, sir. You pleading true? He said he pleading true to still.
All right. Well, then you can't say I'm guilty, but I didn't do it.
Yes. So you're saying that you're guilty? Sir. He's saying he's guilty. Just I'm not misremembering. He told me it was water. That's what he told me.
That's well, you can see it's not a necessity of life here. This I'm just
what you told me.
I know. I know what you're saying, but we're going to clear the record up.
Yeah.
It's somebody's wallet and ID was used, and that was used to forge and commit theft. That's on that case, and then we have the burglary of a building. No matter, but so the defendant has pleaded true in each of these cases and admitted culpability. So the question is, what do we do in the aggravated assault? He is looking at no less than 2 nor more than 20 years confinement in prison. I think it was a loss of $700, wasn't it?
Your Honor, in the burglary of a building, it was actually $7,000.
Was $7,000?
Yes, Your Honor.
But in this one, the wallet contained approximately $1,000 in cash.
Yes, sir. And he's currently, I believe, on probation and misdemeanor court for that offense.
Well, how does he pay it back if he goes to prison for 20 years?
And Your Honor, our recommendation, and we normally wouldn't do this, but he did cooperate and had testified recently in a case for the state involving a serious offense. would be to revoke him on the aggravated assault, keep him on a straight probation.
How can I do that?
Well, it'd be then to keep him on the deferred there for the ag assault and sanction him to the max. But
so you wanted to sanction him? What would be the sanction?
The 180 days.
I mean, I'll take all of that into account, but no, I'm not. With his splendid and rich criminal history and continued, I mean, we're talking about aggravated assault with a deadly weapon here, where cutting somebody with a knife and but okay, we've got this second degree felony and then this state jail felony. What are you saying?
Well, Judge, and piggybacking on what the state just said, one thing we're asking you to give him credit for is that he apparently did testify.
And he's going to be rewarded
for cooperation.
He'll be rewarded and with what I have in mind, but I want to hear what your thoughts are.
I would want to just continue on probation to give him a second shot. But
it's hard on something like this when we're talking about a aggravated nature and then the burglary of a building. But he knows that actions have consequences, and the court is going to treat him with and give him credit for the cooperation he made. The problem you have, though, is that you can cooperate all day long. And did he testify in a trial?
Yes, Your Honor.
See, the problem is that when his all of these prior convictions come out, the jury can't show a lot of credibility to someone because all of that comes out. And the law states that the jury can consider prior convictions against the credibility of someone so that their statements have less value of believability than they would otherwise by somebody who's doesn't have convictions of felonies. And so you may have helped, but I can guarantee you, I know how juries are. If all of these felonies came out, and maybe they didn't, maybe the other side didn't bring them out. And if they didn't, then they don't know about it. But I know it. And it would only make sense that the defense attorney would at least challenge his criminal history in front of the jury and then argue that he's not worth credible belief because the law says that can be taken into account.
So I apologize, but actually can't give me another chance.
Sir, you've had 7 or 8 separate chances here. We talked about how many prior felonies, 7, and then misdemeanors, and then here we're still committing crimes. All right, anything else to add? And the court is going to take into account your cooperation. I'm going to find that there is sufficient evidence supporting each of these motions to revoke probation in cause numbers 1411 and 1831 to grant the motions by a preponderance of the evidence or greater, as the defendant has pleaded true voluntarily, knowingly, intelligently to the offenses alleged or the allegations of violations number one in each case, committing the offense of theft on or about April 6, 2025. And we cleared up what that was about. It wasn't water. It was committing the theft of somebody's wallet and money of $1,000 and ID. And then allegation number 2, failing to report, as the defendant was placed on probation and never reported, and for probation as ordered. And thus, those are violations that he has admitted to. They're proven by preponderance of the evidence or greater. And these motions The motion to revoke unadjudicated probation in 23 CR 1411 is hereby granted. And the motion to revoke probation in 23 CR 1838 is also hereby granted. So your probations are revoked in each case. In this first case, 1411, where you were placed on 10 years deferred or unadjudicated probation. Earlier in that case, you pleaded guilty to that second degree felony voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, even though that case was that final finding of conviction and sentencing of confinement up to 20 years was deferred. That deferred probation has been hereby revoked by this court based upon these violations of probation. You were hereby found guilty beyond a reasonable doubt of that underlying offense, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. And you will be given credit for all time you've served. And there's an affirmative finding that a deadly weapon, namely a knife, was used in that offense. In 23 CR 1838, your probation has hereby been revoked in that state jail felony of burglary of a building where you were sentenced to 2 years in the state jail. That was probated for 5 years. And your probation in this burglary of a building case in 1838 is revoked, and you were hereby sentenced to confinement in the state jail for 180 days. These two sentences shall run concurrently. You understand what has happened today? You've been given the minimum sentences because of your assistance to law enforcement.
Yes.
The order also shall reflect in cause number 1838, the 180-day sentence restitution is ordered, and the judgment in the amount of $7,000. That's what was ordered in the first place. Restitution will continue. We're going to take care of victims, and that will be part of the judgment. Do you understand what has happened today, sir?
Yes, sir.
You did get reimbursed for your cooperation.
Yes, sir.
That the state claims was helpful.
Yes, sir.
But still, you have to atone for the wrongful actions that you made. And I think fashioned a method that shows award. But please learn from all of these. These are now 2 more convictions. That means 9 felonies. That's far too much, sir. Your legacy in life should be doing good things, not being an habitual felon. Please do better. Langston, anything else you want to add?
Nothing from the state.
And we are in recess. Thank you. Appropriation. All right. What's next? License. I've got Christopher Kane and Lance Woodard.
Kane is on the
We reset it for the 15th, Judge.
Yeah, and Woodard.
Woodard is maintaining his innocence, but you can bring him out, Judge.
Yeah, we'll bring him out. Lance Woodward. Let's see.
The 180 days is that you get credit for time in jail?
He gets credit for all time served in accordance with the case.
All right.
He may have finalized his dime on that other one. Oh.
Yeah, that.
And we need Lance Woodward. Who's,
That's
Mr. Ham?
Certainly. Yes.
And, well, there's obviously a clear one that sticks out here, that 1160 is.
Yes, sir.
When can we? Y'all pretty much ready?
Any case that I have, if you set it for trial, I'll be ready.
Sometimes you gotta take some getting prepared for. Come on up.
If I have a special circumstance, I'll let you know, but this anyway.
And we call the matters of Lance Christopher Woodward. That is you,
Yes,
Mr. Woodward, here with Mr. Adams, your attorney, and the state's attorneys. State's attorney. You were charged in 2 indictments, 25 CR 1159 and 25 CR 1160 and 1159, just so that you're clear, that there's not any confusion. You were alleged on or about July 3rd, 2025, to have committed unauthorized use of a motor vehicle, namely an ATV. Honda ATV on that date. State jail felony carries with it they've convicted no less than 180 days up to 2 years in the state jail and a fine up to $10,000. In the indictment, there are allegations that you have been convicted 3 times at least. In 2009, in the 252nd District Court of Jefferson County next door here, for illegal possession of a controlled substance, 2nd-degree felony. Also, you were convicted in Tyler County District Court on March 12th of 2010 for assault family violence. After those 2 convictions were final, it is alleged that you committed the offense of illegal possession of a controlled substance and were finally convicted of that in this court in 2016. And so that means that this state jail felony, if all of this was true, the punishment, which would otherwise be up to 2 years in the state jail, is now enhanced or raised to what would be the equivalent of a 2nd-degree felony. So you're looking at no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. Plus, you were ineligible for probation in front of a jury with a felony conviction, and you have more than that. Do you understand what you face there?
Yes, sir.
Okay, good. In 25 CR 1160, it's more serious. You're charged here with unlawful possession of a firearm by a felon, a 3rd-degree felony, and then the allegations go on to allege that you have been convicted in 2009 in the court next door of illegal possession of controlled substance. And after that was no, they don't. They just allege another prior conviction out of Tyler County. What was the date on this? Fine. Don't allege the final conviction out of this criminal district court for some reason. Which would have made it habitual felon.
The one in 2016 is the offense that they're using to say he was in possession of a firearm by a felon.
Okay, well, the way it was indicted, it came out fortunate for you because it would have otherwise, if they would have used a different conviction, then you would have probably been indicted as an habitual felon because of the sequence. But the way they did it, that sequential the conviction out of this court is not used. So even though there are two priors, it's only going to be bumped up one level. So this third degree felony could be prosecuted. If you're found guilty, you would be sentenced as though it were second degree felony. And you were looking at then no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. If they would have used a different one, it would have been an habitual felon status, but they didn't.
And I may elect to do that at some point in time, Judge, but at this stage, it's there.
Until such time,
Yes,
we just work with what we got. And
in light of him rejecting a 10-year offer, I will likely change it.
Then let's get to this.
Yes, sir.
All right. What's the plan?
Well, the offer was 10 years, as Mr. Ham stated, but my client, he maintains his innocence.
Which he's allowed to do.
Right?
Yes, sir.
I mean, I'm asking.
Yes, you understand what you're looking at?
There's a clear video where we see him in possession of the gun and placing it at the side, trying to prevent the officers from seeing it. He's on a stolen ATV with an ignition that's been modified. It doesn't even have a key. It's hot-wired.
You know that.
I'm stating all that because I'm guessing he hasn't seen the video.
All right. Well, anyway, this is the day where you make a choice. We're moving forward. They say they're going to re-indict.
Yeah, I mean, if he's going to turn down 10 years, I'm going to leave him exposed to 25 to life.
And it's his free will.
Yes,
He can make a choice. So that
and you should do that, sir.
He said he's going to take the 10. He's going to take the 10. He's going to dismiss the other case. So he said he's going to take. I'll sign him up now since he's changed his mind. He initially said no, but I
just have a seat right there, sir, and he'll be with you in a minute. And thank you.
So it's not going to take long.
We'll be in a short recess.
Won't take me long.
Thank you. Okay, I've got a couple of other matters here on this. Do we have any dismissals?
Did them already, sir.
What's this Christopher Kane matter?
That's what we're holding, Judge, to talk to the family.
Okay, so I don't need to act on that right now.
No, sir.
Oh, thank you.
I'll be done in one second.
Thank you. So what's going to happen? He's got 2 cases.
Dismiss one of them.
One's going to be dismissed. All right.
That's the one that's enhanced to the 2 to.
Thank you.
2 to 20, I apologize. 2 to 20.
Want you to know that I changed locks on my back door that had broken.
Oh, yeah.
Yesterday, and there were no injuries during the replacement of the lock. No one suffered any injuries when I was putting that thing back together. I was pretty impressed.
Exits on you.
Well, they've got some neat Christmas. Yeah, no, I'm trying not to. Decorations out. And about, so they've got some real creative things now.
It's
I'm
still just amazed about that drone show. That was just beautiful downtown. But we've been stuck in here so much. I didn't know it was going to occur until I was driving to the bar party, the bar association, Jefferson County Bar Association downtown, the Art Museum, and then I saw that thing. It was just magnificent. I was impressed. I was really what they can do. I guess they bring them. I guess these are people that come in from out of town to do that. I don't know if I would imagine people have the ability to do it if they can get all the drones acquired and then computerized, put a program together that makes the show.
All right. Well, absolutely fine.
You did. No.
Court does call the case of the people versus Melissa Hatfield.
Ashley Feltus for the people.
Tina Saxon for Ms. Hatfield.
Your name, ma'am?
Melissa Hatfield.
Thank you. And the record should reflect while you guys are executing that there has been a in-chambers conference regarding this matter.
That's correct, Your Honor. We discussed some additional reports that I need to provide to Ms. Saxon. Some of those reports are going to have to be redacted, so it's going to take me a little bit of time to do that, as well as just some other collateral cases that are sort of surrounding this in the periphery. But I do believe we're going to have a bench trial waiver.
Yes, Your Honor. Ms. Hatfield has agreed to waive two bench. I have explained what that means, and we are completing.
Ms. Hatfield, is that correct? All right. And you understand that you have an absolute and constitutional right to have this matter tried before a jury. You understand that by waiving that right, it to be tried before this court without a jury present. You understand that? All right. And just so that I have it on the record for the people also waive their right.
We do, and I'm signing the waiver right now, and I'll provide it to the bailiff.
All right. Based upon the statement of counsel, court will consent to have the matter tried before it without a jury. And just so also the record is clear, because of partially part of that discussion, you mentioned collateral issues. There is also, my understanding, a civil matter, which is in 14A, but not before me, which is also proceeding at some point or doing something. So
That's correct, Your Honor. I think the next date for that case is February the 10th. So we were considering the court's February 25th bench trial date. And I think that's agreeable at this time to all parties.
all right.
That's correct, Your Honor.
That would work. Okay.
Should anything change, I'll reach out.
All right. Non-jury trial in this matter then will be set. That's a good date.
February 25th, yes, sir.
February 25th, 2026, 9 a.m. And as I had indicated, so, and I'll put it on the record, that if some of the other collateral issues, both another criminal matter as well as that civil matter, are not resolved, and Ms. Saxon deems it in her client's interest that the matter should be adjourned, that the court will certainly work with counsel in that regard. Counsel out on that. All right.
Understood, Your Honor. Thank you.
Thank you guys very much. And on will continue. All right. Thank you, ma'am. Is that it for my, that's it for my criminal doc.
$100 fine, $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. I didn't assess an attorney fee in the other case. This adds up to $375 or 1,000 days in jail if you don't pay the fine. If you blow this off like the other ones, I'm gonna end up doing a show cause. We're gonna talk about going to jail to wipe these out. $1,000 days would be about 3 years. I can't really do that on a 90-day misdemeanor, but I'm serious. I want you to pay these. And don't get more of these because the prosecutor won't give you that indulgence. And your sister, did the car get towed?
Yeah, I got totaled completely.
Oh,
I was in an accident.
Oh, yes. All right, when you're in an accident, you don't have any insurance, you're gonna get sued by the other people's insurance company. You're probably tired from being up all night, so this ain't good on several different fronts, but I'll send you out to the court office. I want a payment plan with the kind where you actually make a payment. All right, good luck to you on your license journey there. You're good to go. Does that finish you, Ms. Strong?
Aside from the fail to appears,
All right, I think, did we make a record on those?
we made a record on Lucio Gomez Arias, but not Jacqueline Giselle or Nevaeh Horton.
All right, Matt, do you have those?
I do.
Do
I
you
don't have the paperwork. I gave it. I left it with me.
Well, let's get those.
November 1st and confirm the court dates. I also sent him a letter with his court dates.
November 1st?
Yes, Your Honor.
All right, we're gonna do a bench warrant, $400 cash or surety bond, 48-hour hold. Oh, Ms. Gazelle had another one.
Yeah, she had 2 files.
Yes, we'll set them both for, each of these defendants got a driving suspended, and then they liked it so much they got another one. In Ms. Gazelle's case, we'll reset it. So she's ostensibly ill, only out 1 week. That's not bad. And Mr. Gomez, Lucio Gomez Arias, you can't just not show up. So bench warrant in each case with a 48-hour hold. Thank you. Does that complete your obligations today?
We also have Nevaeh Horton 25-2100 SD.
Yes, Nevaeh Horton 252100. I don't have the face sheets on these. I just have I don't know if I have phone numbers. What's the status with this one?
I spoke with her. She called back on October 29th, left a voicemail. We've played phone tag ever since. She did receive a letter with her court date, but we have not had contact other than phone tag.
As I said, I'm always amazed at how unseriously people take these matters. Yeah, this was a bad situation, a high blood alcohol accident on the way to work. Do a bench warrant. $750 cash or surety with a 48-hour hold. Again, serious ramifications here. This defendant works locally, lives in Edwardsburg. So if anybody knows Nivea Horton, she needs to contact her lawyer. She ended up in jail. It says where she works, so they could just pick her up at work. So please contact your attorney before you get arrested. All right, thank you.
Thank you.
All right, I've got Ross and Luke here. Ross has a number of cases. Luke, what do you have left for me?
Two, Judge, Mr. Zambrano.
All right, let's do him first. Good morning, Mr. Zambrano. David Zambrano charges purchasing a pistol without a license. Been a long wait for this. At this point, Mr. Zambrano, you wish to continue your plea of not guilty?
Yes, Judge.
Okay, and we'll set a final pretrial. You got a payment plan going, I think, on that other traffic stuff. How are you doing on that?
I appreciate it.
Have you made any payments on it?
Yeah, with the first one, it was monthly.
Yeah, the next payment is due actually on the 7th, so I guess later this month. All right, you still have the Mishawaka address?
Yes, sir.
All right, you're good to go. We'll set a pretrial on this. I don't know the facts on this, and I'm not supposed to know too much. This one does require that the gun get forfeited if you're convicted of this, so we'll see where we go. But I'll continue your plea of not guilty and set a last pretrial with your lawyer.
Thank you, Judge.
I have a lot of last pretrials. All right, Luke, what else have you got for me?
Judge, I am entering a limited appearance for Levon Comer, who has not appeared. I think the David Moore Law Office, I know the David Moore Law Office was representing.
Levon Comer, okay, there it is.
Yeah.
Stanku. Let me go get that from Luke. He claims that you have it. Oh, now I have it. Okay. Well, that is good. Levon James Coomer, charged with operating while intoxicated and failing to yield. I sure get a lot of those that result in an accident. The defendant resides in Indiana. He's represented by attorney Stanku of Mr. Moore's office. Mr. Nossing is here by limited appearance.
process. Thank you.
Good morning. I'm
After
calling.
you have finished your message, just hang up. Or to hear more options, please press 1.
This is Judge Middleton calling for Levon Coomer. You failed to appear for your court hearing this morning at 8:30 in Centerville. I'm about to issue a bench warrant for your arrest. My suggestion is that you contact your lawyer immediately. Thank you. Have a nice day. I'm not sure what that message said, but we're gonna do a bench warrant of $500 cash or surety. A 48-hour hold. This is also a civil infraction. Maybe that'll get a reaction out of somebody. Seems like if he goes to expense of hiring a lawyer, he'd show up, but maybe there's some communication issue. All right, thank you for your help this morning.
Yeah, thanks, Jeff.
Ross, thank you for your patience. Looks like we've got a few matters to deal with. Logan Herrick. Good morning, sir. Are you Logan J. Herrick?
Yes, sir. Good morning.
Thank you for your patience. I guess I tell people this is part of your legal education. You get to sit here and watch other people's cases. You're charged with operating while intoxicated, which you heard is a very common offense. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. You're also charged with refusing a preliminary breath test, which carries a $165 fine. Prosecutors agreed to dismiss that breath test charge. Which is going to save you $165. They've also agreed to reduce the charge to impaired driving. This happens a lot. Impaired driving is a lesser included offense of operating while intoxicated. It's punishable by up to 93 days in jail and a fine of up to $300 rather than $500. Carries 4 points on your driving record rather than 6. And most importantly, it allows you to keep a restricted driver's license to drive back and forth in the course of work, treatment, school, other limited purposes. Do you understand?
Yes, sir.
And Mr. Truckee, you confirm the plea agreement?
That's correct, Your Honor. Plea to impaired driving and balance of dismissal.
All right, Mr. Herrick, you've been sitting here patiently while I read the advice of rights a couple of times. Do you understand you'll be giving up those rights by entering this plea? There will not be a trial?
Yes. Yes, sir.
Tell everybody, take the test. You'll end up getting your license suspended even if the charge is dismissed. All right, were you driving a car on October 10th at about 1 o'clock in the morning, 131 down near White Pigeon? Oh, you were going to Harder Road and Williams Road out in the deer hitting territory. Where were you going?
I was going back home, sir.
All right, you live in White Pigeon. Where were you coming from?
Friend's house in Pablo.
All right, so you were cutting across Harder Road, headed westbound.
Yes, sir.
That is a real good place to hit a deer. What were you drinking?
Bush Light, sir.
How many?
Many. Like 5 or 6.
What was the blood alcohol, Mr. Truckee?
2.134, something like that.
All right, that's probably more like 6 or 8, but I appreciate your candor. What do you do, sir? What's your occupation?
Concrete finisher.
Are they still doing any?
Yes. Yes, sir.
Well, now that it's 4 degrees out, that might have terminated your season. I think when it's 30, you can do it, but that's cold work doing that in the wintertime. All right, I'm gonna set this for sentencing. Let's see what kind of baggage you got here. You got no criminal record. You got no driving record. I don't even see very many people like that. So you got a completely clean record and a relatively low blood alcohol. Was there an accident here?
Yes, sir.
There was a single vehicle accident involving an attempt to miss a deer.
I was being facetious, but it is a terrible place. Anyway, there are lots of deer all over our county, but down there, there's lots of rural farmland and woodland. All right, let's see, Mr. Truckee, what you've got. I'm going to be gone a little bit in January. But for you, oh gosh, I already got a bunch of stuff set that day. Jordan's cases. Gibson. Oh, wait a minute. How about January 5th? Well, that's probably too much for my probation department. No. Let me see, do I have you that day? No, I don't. So let's look at for you for Wednesday, January 7th.
That should work. The circuit court trial date on the 6th, but I imagine 17th.
All right, let's set that for, if we have to move it, we can. All right, sir, why don't you take this out to the counter? And I'll see you on January 7th. They'll give you some more information about when to come back.
There you go. All right, take care. Call me before the 7th, okay?
Alvarado Asuncion. I didn't say that very well, and I apologize. Could you say your name for me?
Angelo.
And what's your last name? What's your last name?
Alvarado.
Okay. You have the same sort of plea offer as the last defendant. You're charged with operating while intoxicated. They've also agreed to reduce that to a charge of impaired driving. Did you hear everything I just said to the last gentleman? Well, let me repeat it. Impaired driving is better. It's punishable by up to 93 days in jail and a fine of up to $300. Carries 4 points rather than 6, and most importantly, will allow you to keep a restricted driver's license to drive back and forth to work. You understand?
Oh, yes, sir.
And the agreement is they're going to dismiss the operating while intoxicated for a plea to that lesser charge, which sounds like a fair offer. I don't know any of the facts yet. You heard me also go through the advice of rights several times. You might even be able to recite it back to me, but you understand you're giving those up by entering this plea?
Oh, yes, sir.
Anybody threaten you to get you to plead to this?
No, Your Honor.
Promise you anything?
No, Your Honor.
All right, now, I'm gonna make some guesses here. This occurred on August 15th of 2025 at 6 o'clock in the morning at Broadway near 131. We get a lot of accidents there. Were you staying in one of the hotels near there?
Oh, yes, Your Honor. I was out here for work.
All right, that was my next guess. So you were out here on some sort of work assignment.
Yes.
All right, you're from Saginaw.
Oh, yes.
Took me 3 days to hitchhike from Saginaw. I told you that the last time. So this is very early in the morning near the hotels. Tells me out of town worker, work. So where were you going?
I was going back to the hotel.
Where had you been?
I was at Sam's bar.
All right. That was real early in the morning. Where did you go between Sam's bar and then?
I was pretty much there all night. We met when I was there. I met the owner, and I was drinking with the owner.
All right.
Till then.
Sam?
Yeah.
Well, the original Sam, Miss Bedford?
Yeah.
Oh, well.
All right.
Yes, sir.
I've known her, she's known me essentially all my life. She was a friend of my mother's, but I thought she had sold it.
Nope, she's still going.
Well, she can't. She knows better than that. She can get issues, but all right. What were you drinking?
I was drinking some Modelo's, and she offered me some shots. I offered her some shots. Yeah.
All right. Well, was there an accident?
Nope.
How they happen to pull you over?
I fell asleep at the light.
Wow. That's not a good place to do that. What were you working on? What was your project out here?
We were building the leachate tank for the landfill.
All right.
3 Rivers.
I think you told me that before.
Yep.
So that's probably a nice paying job.
Oh, yeah.
Are you still on that project? You're on something else?
No, we finished it a bit in Bay City. And after Bay City, I'll be in South Carolina the beginning of next year.
All right, well, let's get this done. January 7th, I've got Mr. Truckee set to be here. Can you be here that day?
I actually leave for South Carolina the 5th.
All right, well, let's see what we can do before you. Depart. Not a lot of time left in December.
I will be there for 2 full weeks, and then I will come back for a week off.
Mr. Truckee, you're set to be here on the 15th. I think maybe I could cram this in there.
During last pre-trials?
No, you're set for sentencing Monday, December 15th
Oh,
at
December.
11.
Yeah, that's fine with me. I have a 10:30 with you on 15th.
Yes, I'll set this for 10:30. We'll set it for 11.
I have a hearing, CAS Zoom hearing at 11, but the 10:30 shouldn't take long.
All right, well, let's do our best.
Appreciate it.
All right, you take this out to the counter.
Yeah.
I think your license is still valid. Don't do any more dumb stuff before I see you
Sure won't.
on the 15th.
Thank you, Ron.
All right, you're good to go.
All right, good. Okay. Well, it's about the 15th. Yeah, so somebody will be in contact with you, so make sure to answer any calls as they can. 269.
All right, Ross, let's keep plugging away here. All of Mr. George's cases got adjourned. I think there were 6 or 7 of them. And some others also got adjourned. So we would have even more folks here, but we're doing all right. I appreciate everybody's patience. Mr. Stainer's in custody. We'll try to make sure he gets there for lunch. Dylan Bailey. Good morning, sir.
Good morning. Good morning. Are you Dylan Michael Bailey?
Yes, sir.
You got charged with filing a false report of a misdemeanor. It's alleged that on September 9th, you falsely reported a misdemeanor assault and battery against Samantha Bailey to Deputy Jesse Raymond. And then you falsely made a report of an assault and battery against Dylan Bailey to Deputy Raymond. So you reported that somebody assaulted you and Samantha Bailey. Those are misdemeanors. The way they're charged, they're punishable by up to 93 days in jail and a fine of up to $500. Allegation is that you called the Spartan Motel and said that you guys were assaulted by somebody named Robin. Then they reviewed the video and determined that that isn't the way it transpired. According to this, Mr. Truckee, they're going to dismiss count 2 if the defendant pleads to count 1.
That was the offer.
Oh, and he's declining the offer.
That's right.
Oh, again, I'm not clued in enough to see what I'm doing here. I didn't see the marks. All right. Mr. Bailey, do you still live at the Spartan Motel?
No, sir.
You're now at North Main Street?
Yes, sir.
All right. Have you seen the video on this case?
I have not.
All right, so parties need to review video. All right, I guess it's gonna be a interpretation of your version of the facts and what appears on the security camera footage.
That was a 2023 filing, September 23.
Yeah, 2023, so this is 2 years ago besides. All right, I don't know much more about this, but we'll set a final pretrial. Are you missing work right now?
No, I just got off work at 6 o'clock.
So you've been up all night?
Yep.
All right, go and get some sleep. Stay in contact with your lawyer and I'll give you a new date to appear.
Okay, thank you.
I don't
Thank
know
you,
what that
Robert.
is yet.
No. Thank you. Hold it up.
Judge,
Yes,
thank you for kicking me in the ass. Do you remember me?
are you Thomas?
No, I'm Adam.
Oh, yes, yes,
You talked to my boss, Ron.
yes.
He told me what you said. That week I took care of it.
Very good.
Have a wonderful day, sir.
All right, thank you, sir. Glad it worked out. Zachariah McCreary. I think I got this right. Adam, yeah. Are you Zachariah McCreary?
Yes, Your Honor.
You got charged here with 2 counts of domestic assault. Let's talk about those. It's alleged that on November 1st, that you assaulted Miranda Miller, 2 counts. Those are misdemeanors. They're punishable by up to 93 days in jail and a fine of up to $500. They would also require that you would lose your privileges to use a firearm. Prosecutors agreed to dismiss both of these charges for a plea to disturbing the peace. You heard me say this a couple times. You've been watching carefully all morning. Disturbing the peace is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. And as I said, it doesn't matter who started it or who was right or wrong. Was there a quarrel, argument of disturbance, generally in a public place? Are you going to plead to that charge?
Sure.
Did anyone threaten you to get you to plead to that charge?
No.
Or promise you anything?
No.
And did you hear me go through the advice of rights orally here in the courtroom a couple of times this morning?
Yes.
And you understand you're giving those up by entering this plea?
Yes.
All right, this starts the way they often do. You had been drinking that day, correct? What were you drinking?
Crown and root beer.
All right, and then you got in an argument with your girlfriend who was Miranda Miller. Is that correct?
Yes.
Do you remember what you were arguing about?
Me leaving.
As in ending the relationship or just leaving the house?
Leaving the house.
Because you were drunk. Anyway, it says she fell over. And then you left before the cops got there. She fell backwards over an ottoman. She had a bruise on her knee and a lump on the back of the head. The prosecutors agreed to reduce this, so I guess I'll take it at that. So will you accept that? You and she got into a argument in the apartment? And that was now number 3 North Main Street. Which building is that?
Very first one.
Well, what's below it?
CZ.
Okay. All right. What do you do, sir?
Construction.
What kind of construction?
I'm a general contractor. So anything, your house is.
Where are you from originally?
Sturgis here.
And are you and Miss Miller still together?
Have no contact.
Well, you've had no contact, so it's hard to tell. But apparently, when the prosecutor does this, they assume that I'm going to not impose any jail. The good news is this doesn't carry a firearm restriction and it shows as disturbing the peace. The bad news is it doesn't allow for a deferral. Where are you staying now?
My parents.
Which is in Sturgis?
3 Rivers.
Where in 3 Rivers?
At the airport.
Okay. Let's see if there's any victim request in here or anything.
Miss Miller is here also.
Oh, she's here. All right, great. I didn't want to do this without some input from you. You've been waiting here all morning. Why don't you come up and have a seat? Normally, when the matter is reduced to a disturbing the peace from a domestic assault, it's done after the prosecutor confers with the complaining witness. But I don't always know that. There's no prosecutor here this morning. So you're the complaining witness in this case?
Yes.
Do you object to the reduction to this charge of disturbing the peace? Did you get any medical treatment as a result of this?
I need it.
So you don't have a medical bill or any unpaid restitution. I'm about to sentence him, and normally what I do with these is fine and cost and time served. The no contact provision would be lifted. Did they explain that to you?
Yes, I requested it to be lifted.
All right, so you don't have any objection to this? All right. This was a long morning for you. You got to see what happens on the first Friday of the month in Centerville. A lot of stuff. A lot of heartache. All right, but one thing that happens when something like this happens is hopefully the red flag goes up. Alcohol is a problem here. And you find that you don't know what you got till it's gone. You're not been allowed to have contact since November 1st. So it's a chance to step back and look at what's going on in your life. What are you doing with your work? What are you doing with your alcohol consumption? What are you doing with your relationship? So if there's any positive that comes out of it, it's that.
Judge, I'd like to note that Mr. McCreary did complete a domestic violence course at my direction, a 4-hour course. It's not, the one that you sentence people through, but he willingly completed that and then indicated to me that he learned a lot. He also took a number for a counselor for me, so he's willing to improve himself and do that exact self-accounting that might be necessary.
All right, this is a little bit unusual. I didn't think they would normally reduce this, but they did, and they've got their reasons. Not the least of which is the complainant does not object. You got arrested on the 1st. Posted bond on the 6th. Did you do 5 days in jail for this?
No, I didn't see the warrant until.
Oh, you didn't get arrested until you got arrested on the 6th, posted on the 6th. 1 day jail credit, 1 day. I don't have any money here. This carries a $100 fine, $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee, which is $375. Can you pay that today, or do you need time to pay it?
Pay today,
All right, very good. Now, the no contact is lifted. You guys can go out to lunch. That's up to you. But like I said, maybe this was an eye opener and reassess what's going on. All right, sir. The court officer will take you out there. You can pay the fine. I don't see that you owe me any money. And you're good to go.
Thank you,
Thank you.
Take care of yourself, sir. All right. Wish you the very best.
Are you Dakota Suarez? All right, let's do that one. Then we'll do Mr. Stainer.